I'm not economically so well that I can travel from.
1 minute, please. You filed the cases after the differences had arisen in Delhi itself. You were staying in Delhi at that time? With whom?
Gurugram.
With Gurugram at that time? Now you have moved out from Gurugram. Your brother is still there. Who's there in Gurugram?
No one is there.
How are you staying in Gurugram?
I used to stay in Gurugram at my matrimonial home. Then I got kicked out from there.
I don't think I was very clear in what I wanted you to answer. You filed the 125 and domestic violence cases in Delhi, correct? Those must have been filed after the differences had arisen.
No.
Correct? So where were you staying at that time when you filed these cases?
At that time, I was with my father. He was employed here. But now, since there is no economic source of income,
father is still here?
At that time, he was here.
Now he's not in Delhi?
No.
What is he doing here? What is your father doing?
He was a security guard, and now he is in Siwan, Bihar.
He is in?
Siwan, Bihar, district Siwan, Bihar.
Okay. Right now. Ex parte order. Accepted. Services complete as per the ex parte orders. Allowed parties to appear before the transferee court on 18th of December 2025. Item 2. Yes, please.
Please. Item 2.
I appear for respondent. My learned friend is there, my lord.
Yes, please. What do you say? For the respondent. Who's for the petitioner?
Yes, my lordships, I am appearing for the petition in this matter.
Yes, please.
My lordships, I have pressing this petition primarily on 4 grounds. That the distance from one-sided, where the petitioner right now is residing, is 250
the case
kilometers.
is already fixed for now for cross-examination of the witness before the local commissioner.
Yes, my lordship. My lordship, the one-side distance is 250.
Has already undergone, had a heart attack.
No, my lordship, not heart attack. No, my lordship, not heart attack. Even the reports which has been filed by the learned
please let the case is at the last stage. We're not transferring it.
Grateful.
Grateful.
Trying to accept the prayer for transfer, and hence the transfer petition is discussed.
Grateful.
May I request something?
Suppress several facts. Let's put it very clearly. You suppress several facts in your transfer petition. Item number.
Grateful.
Is not taken up for hearing.
We just inform your lordships, that we are going to crush less than 5,000.
That's not relevant. You don't have the EC.
No, we don't need the EC. Your lordships
require the EC.
No, we don't. It's in order of the
NGT. Not correct.
No, Malad. There's an order of the EC itself, Malad. The order of the NGT itself.
Let's see.
Page 37. As per EIN, that's 5J Malad of the notification.
Let's see.
EC is required to sugar industry only when crushing capacity is more than 5,000.
That's not correct, because our order, interim order, clearly said without EC you will not.
No, that's 3-1 order, your lordship's order of 3rd of January, Mother.
Yeah, just come to that
itself, says.
Just come to the 3rd.
Mother, just kindly come to 181, your lordship's order. 180 at 182. 182. 181, 3rd January order of 2023.
1 minute. Yes.
In the meanwhile, we are inclined to partly stay the operation of the order. That is the direction given in para 30, restraining the appellant from crushing of cane till
that was on the basis that you had the valid right, you had a right consent to operate. Now turn to
our consent. Kindly see.
Now turn to the order dated 1/9/2023.
Then see, subject to the conditions, the appellant will not exceed crushing 5,000.
Correct.
In terms of 5J.
But now come to the order dated 1/9/2023.
That's right. That's at page, my lord.
And there's so many allegations which have been found
No,
against
that
you,
also, my
the
lord.
slush which has been
No.
deposited.
Kindly see. Kindly see. On the deposit being made, we've deposited that money. my lord.
Your deposit 3 crores, but
Yes.
given the bank guarantee of 10 point,
Conditions
you're
imposed.
given the bank guarantee of 10.34 crores.
Yes, we've done all that.
Now come to the last part,
Yeah.
second part.
It is, if EC is issued to the appellant, it will comply with the conditions imposed thereon. It will be entitled to operate. We will not have any comments on whether EC should.
Whereupon it will be entitled to operate.
That is, if it's beyond 5,000.
Look, the earlier order merged into this order. You can't operate.
Just kindly see
You
5.
can't operate without EC.
Kindly just see 5J, Malad, the notification
That is mandatory.
at page 35 of the IA, Malad. The notification itself says so.
Page
Page 35, condition 5J
35
of the IA, Malad, that we've filed, Malad.
Yes.
It says sugar industry, 5J, sugar industry, more than 5 TD, then the general condition shall apply. That's the notification, Malad.
You don't have the IA? What is the IA number?
2667.
Yes.
But did you not have your consent to operate is also come to an end in 2021?
No, we've got the consent now, Malad. We've got the approval.
Came to an end in 2021.
Yes, but we applied, we got it, Malad. We showed to you.
Which shows
Just give it to my lord. We will not operate without consent to approval. We also say that. Yes. We are item 15, approved renewal
That's
of
one
consent to
verification.
operate. You also may pass the order. We will not operate.
Mr. Sipal, we are looking at it. We are not neither rejecting nor accepting your prayer at this moment.
Yes, I
Let's read
appreciate
it
it.
first. And we'll also ask you to deal with the allegations made in the fact finding which has been done, the committee reports which have come. You have
Now the committee says, Malad, that we are entitled to ex post facto. That also is there. Malad. That's it.
come to the findings recorded against you.
Yes.
With regard to the discharge of the slush.
Yeah.
And how are you operating from 2021 to 2023 without consent to operate?
No, that is violation and they now recommend it in our favor.
That
Your
therefore,
Lordship is right. I cannot defend. There's no question of defending that.
That
But
you cannot.
now they have operated as
no, please. So,
You're
as
right.
far as that is concerned, then we
That
confirm
fine is, that fine
that
is
means
imposed
one
on.
minute. Therefore, then we confirm the order as far as 3 crores and 10.5 crores. That
We have paid that, Malad.
so we have to pay that.
There's no doubt we paid that, Malad. Now, all I am saying to your Lordship is even
And
now,
comes to the allegation with regard to the
Malad, Malad, I accept that. I am not disputing
I will
it.
show my lord the
Just hold
conduct
on, hold on.
also.
I am not disputing
Even
it.
that 5,000 what my lord Landlord Senior is saying, their own affidavit says that they are doing it more than 5,000. They are admitting once earlier they have stay calm,
Yes,
but
yes,
when
yes.
we pointed out this honorable court, they filed affidavit and they accepted that yes, we are producing more than 5,000.
Just one second.
that affidavit.
But page number 5 of their affidavit, my lord may have the which they have filed.
Malad, may I point out at page 153 if your Lordship don't mind,
Just one.
in our IA.
My lord, the affidavit which they have filed on 28th September 24,
28 September.
2024 at page 5, middle of the page, my lord.
So that affidavit ends at page number 4.
My lord, this affidavit is
5,000, how much?
Comes to average of
But
5.15.
Tender affidavit, it's
That's correct.
Yes.
You exceeded.
Comes to 5.15.
Yes, we accept that. Yes, we accept.
page number 5, my lord, middle of it.
Yes.
Married, my lord. According the consent of operator has been granted to the applicant and therefore applicant could harvest and sugar cane crops and crushing season from 6th November 23 till 25th April 24, which is 172 days. Applicant has crushed so and so metric ton per sugar, which season, which comes average 5,850
Correct. That is correct.
metric ton.
We have disclosed that.
Despite my lord, I'll show you further.
But on up to that, then you require an EC.
That's why, therefore, we are not doing it.
One minute. Moment you exceed that, you require an EC.
Yes.
Will the EC then not be required even if you want to come down?
Manoj, no, kindly see 153.
So 1 minute. You may require an EC. Once you exceed, you require. The issue is this. If you exceed 5,000 EC as per you also is required.
No doubt. 5,800 we did.
You have exceeded that as per your affidavit.
Correct.
Now, once you've exceeded that, then EC must be required even if you want to bring it down below 5,000.
Manoj, kindly choose 153, Manoj, of the IA, Manoj.
Even my lord, last order has not been complied.
You have to be strict on this. We all facing the brunt in Delhi.
No, we are all. I agree entirely, Manoj. I am not for this. Manoj, I am against this myself personally, Manoj. There's no question. There can be no compromise on this.
Last order, my lord, they are still operating.
Hold on. There can be no compromise.
As if today, despite of a last order, my lord, I can pass the document to show. My lord, may have this is a electricity supply online usage, my lord, at 74. My lord may see the electricity usage is 17. 74 I have marked, my lord. This is what we have taken out from the website of electricity. The usage is 17, which shows that they are still operating. And plus, my lord, there are receipts which they are buying a sugar cane and they are operating. There are videos we have made. As if today, my lord.
No. Kindly see.
They have not even complied.
No, not at all. Kindly see 153 if your lordships don't mind. Page 153. Because we crushed beyond. Now let's see what the
Beyond, then EC is required. This cannot be.
no doubt about it.
Can you get over that requirement by saying that I will now crush less and therefore EC need not be given?
Kindly see what happened
Need
was
not be obtained.
it was
That's the short issue.
your lordship, it was 800 TCD up beyond 5,000. It was not as if we were wanting to violate. It's only because the average turned out to be that. But
You are aware of it. You are aware of it.
I plead guilty, I'm not saying no, but kindly come to 153. I'm pleading guilty on that,
This was
April
April of this year, Mr. Sibling.
I am pleading guilty on that, and that's why I told them,
How are you to be trusted thereafter?
your lordship,
We
we'll
need to
file
just go by your saying that
we'll
you could
file
not
an
ex-
undertaking in this court, otherwise the thing will go under, The factory will go
Let it go under. Let there be a good
29,000
example. Let there be a good example.
29,000 farmers. Just give me a minute, Kindly come to 150.
The farmers are the ones who are suffering, not
That's
they,
right. So
not
therefore,
them.
we
They're facing the brunt of the
file an
pollution.
undertaking before your lordships, and he'll go.
So one, we are now asking them to encash the bank guarantees, full of 10 point so much crores, as well as 3 crores. That will be now encashed. This is not done.
All right. So, at least let me read 153 and then allow us, please, and let them encash the bank guarantee and let him file an
This is
undertaking.
a clear violation of the.
Yes, let me also.
It's been done before,
Hold on.
172.
At the moment, I am only pleading with the court that it has impact not only on the industry but on the farmers also. So therefore, we'll give an undertaking, we'll file an affidavit, and if I violate it, I'll go to jail. But I will give that undertaking.
What has happened in this case
It's
is
terrible.
doubt it should be.
It is terrible. It's terrible.
The environment acts are not toothless.
No, absolutely. In fact, this should not be done.
And in fact, prosecution should be there. There is no doubt. We don't want to pronounce what.
Prosecute me tomorrow.
You probably pronounce a guilty verdict. We have not yet pronounced that.
Prosecute me tomorrow. You will say that. Now, the environmental committee has said that On the violation also I am entitled to, this is a case, a fit case for which I am entitled to. But that I can't seek an order because Justice Gawai has passed that order, of ban. So I'll have to go there on the 10th, which is listed. But in the meantime, I'll file an undertaking. Your Lordship may direct encashment of bank guarantee. I can't do anything about it, but I'll file
That's
it.
directing. There's no doubt about it. I'm going to ask the Pollution Control Board to also to take into account the affidavit and proceed according to law.
That's
May direct the Pollution Control Board to conduct the, they can file the report.
The last date said without EC will not operate.
See page 41
No,
of the NGT
no.
order.
Now, Mr. Sibble, we'll have to examine the issue. When you exceed 5,000 by reducing it, still you can get over.
Please examine it, I don't mind, but
So, but now you stop it.
kindly see page 41.
No, please.
Of the
We have to be strict. We have to be strict.
No,
Maybe
I-
it's going to be very harsh.
I
but
agree.
That's the weather on the pollution is
I-
also harsh on us.
I don't dispute that, I can.
May I make
I'm
one
pleading guilty. My request to your lordships is, that give us this one time, generosity, but allow.
Not generosity in this.
I am giving an undertaking now. Your lordship will send me to jail.
According to them, you're violating the order dated 12/11/24.
I'm sorry,
You're violating the order dated 12/11/24 as on date.
1,800,
Not then, now.
Now also.
Now you're still continuing to crush cane.
not after. We have
Malani,
not-
direct the.
Have you stopped your operations
Yes,
altogether?
sir.
we have
File
not
the
crashed anything.
Have you stopped your operations?
We have not crashed anything to be sold, we have not done that.
To be sold.
Then I started just now, last week, that's why we have come. And we
You're
have-
buying
The
cane.
Pollution Control
have
Board
the
to
consent
conduct the
to operate.
inquiry.
You're buying cane without crushing it.
Truth will
We
come.
have consent to.
They have proof to show that you're buying cane now
Yes, we are, but we have consent.
without crushing it.
We have consent.
And
to operate.
why are you spending so much electricity then if you're not crushing
As I
it?
said, we are not crushed yet, we have not sold any.
Okay, we'll ask the Pollution Control Board to verify that fact. In the meanwhile, we are asking for the encashment of the bank guarantees.
Please also direct to the Sugar Commissioner, Lord.
We have consent to operate now,
We'll take it next week.
We have consent.
Let us see, Mr. We'll know what, you have made a statement at the bar. Let's examine that statement. We have not done any.
Operate,
No, let's have that. Let's have the report. Right now.
Please appreciate. We have now consent to operate.
I understand that.
And
but
in terms of,
we want to just verify what's the
in
present
terms of
position.
that consent, I mean.
Let's have the report. Let's have the report. Right now.
Then your lordships may say, instead of consent to operate, can I crush at all or not?
No, you are not. We have told you on the last date, you will not, by order dated 1/9/2024. It was very clear without EC, you will not operate. And we have then clarified it in my last order.
Our understanding was that under 5J, because of notification, as long as.
Wait, Mr. Are you crushing today or not crushing?
A day before yesterday, he started, he said.
Oh, no.
Yes.
You first said he was not crushing, today, no. Now when we say, Mr. Sibble,
Day before
sorry,
yesterday, he.
sorry,
It is not being.
this is not being,
There is no
you're not,
output as
you're
of
not
now.
being, you're not,
Your lordships may say status quo, no output as of now. Please pass that order.
what is this,
It is
Mr.
fast,
Sibble? You accept this violation,
Yes.
you have crushed more than 5,000.
That's-
EC was required. You didn't have consent to operate from 2021 till 2024. The villagers are suffering because the slush is
Yes,
all accumulated over
It
here.
has been cropped up, my lord. There is a complaint of fly ash which is being.
There is a issue, your chimney height is reduced because of the airport.
I got consent to operate.
In 2004.
My consent to operate is now obtained. We say that do not crush. In the court, we are
But
told we
that
are
on
not
the-
crushing. When we say we are
On
appointing
the
ourselves
understanding
to
of your
speak,
lordship's
yes,
order.
we have started
It's
crushing.
your lordship's order which said that under 5J I can go. It's your lordship's order, This is not contempt.
No, please, look at our order of
12/11.
12/11. Read
But
that
that's
order.
their level for environmental clearance. We don't need it. Under 5J, we don't need it,
That's a debatable issue.
But therefore, I'm saying
Okay.
I'm not violating the order.
No, in our order dated 1/9/2024, 2024, we had 23, we had very specifically said, you apply for EC and without EC, you will not operate.
Madam, Lordship, that
We have to be strict.
that
No,
is
Mr.
not,
Tribal, sorry.
not required.
Sorry, Mr. Sibling.
Madam, then kindly do it. Madam, if the EC is granted, there's a stay now, Madam, so I can't even get the EC.
No, we have permitted you to get.
No, Madam, there's an order of Justice Gawai, we can't do it.
That we have permitted you to move an application.
No, Madam, no, we have
We
moved.
have, in the last order, we have said, in our order, we have said
We have
that.
moved.
Yes.
No, we have said that.
No, but no, on 153, they say I can't go ahead.
No. What we have very clearly said, you can move that court for grant.
See, 153.
He violated the order dated 3/1/23. 3/1/23 order permitted you to crush up to 5,000 provided till the time EC is granted.
Yes.
Now, without the EC being granted,
Then
you
it's
exceeded
beyond
5,000.
5,000. Till EC is
You
granted.
exceeded 5,000.
Your Lordship is right, but I just want to clarify. Till EC is granted, then I can crush beyond 5,000. It is not.
This order said you will keep your cane crushing less than 5,000.
Yes,
That you violated.
and you need EC
That
beyond
you
5,000.
violated.
And you need.
You violated this order. Where is the question
We
of
did.
trusting me again?
We did.
This order was also on the basis you had a valid consent to operate, whereas in fact, you did not have the consent to operate.
We had a valid consent to.
No, not in 23. You got into 2024.
2024, 14, Manas, 24.
No, you got, when was it? When you did not have from 2021 to 2024, you did not have valid consent to operate. Please check it up.
I think we had it, Manas.
Just check it up. I may be wrong on that.
Yeah, you had it. We have consent.
You had valid consent to operate from 2021 till 2024?
That's what I'm saying. Yes, we had.
Where is the document?
Manas, I'll give it. It was never.
Did we have
I'll
valid
provide
consent
it. I'll provide.
Operate between 2023 and 2024?
It's one set of records, he did not have consent.
We have got consent.
I know that.
2014.
This order records, he did not have consent after
No,
20.
since 2014, I've been having it. It's page 1, page 72. It's renewal every year, page 72, Manas. Of the IA, Manas. It's there. Page 72. That's the consent to operate, Manas. And that's 28th January 2014. It's not that we were not operating. But yes, we violated it. There's no doubt about it.
72?
Cane crushing sugar shall not exceed 5,000. Your Lordship
This
sees
is
that?
for 5 years though, Mr. Singh.
Correct, but that was
After
renewed.
that, was it renewed?
Yes, it was.
Where is that? Where is
I
that?
can say, but I have instructions that we.
Where is that?
He says he has the document of 2220.
Please bring the document at 2 o'clock. Please bring that document at 2 o'clock. We want to see the document.
I'm
You have the right.
parted at 2 o'clock.
Because there's so many violations, then they have to be a little strict. Maybe
And it'll be
there's a
tomorrow. I'm
half.
in a parted at 2, Manas. I'm on my legs in a parted. Tomorrow morning, Manas?
No, we just see that consent or let him get it as soon as possible,
All
take
right.
it over.
Obliged.
On the last occasion, your lordship had asked about the trespass. We had actually inspected the premises on 21st. On the ground, on the basement, there is a tenant. We have some photographs also. If your lordship permits, we can place it on file.
It's been rented out.
Yes, by the.
Lord, I beg to appear for the appellant.
Yes, please.
On the last page, my lord, your lordship can see the address also, Cutoff House.
Lord, let us.
My lord, SEBI had moved the application. After moving this appeal, they have illegally taken occupation of that premises. They didn't get a stay from your lordship's court.
Yes, Lord, Lord, at the first blush, Lord, an impression which has been created that we have trespassed into the premises, my own premises. Now, please see what has happened. Now, there are two agreements, both dated 27th of June 2011. And then, in pursuance thereof, as against 7 crore 89 lakhs of rupees, for which these two agreement
Total amount to be paid
7
was
crore 7 crore 89 lakhs.
7 crore
89 lakhs. So, and these are all documented, registered document. Now, as against furniture and fixtures, I received 1,54,75,000.
1 crore.
54,75,000. Now, as against these two properties, I received.
If you come to page 3, what the amount you have received is 1 crore 97 lakhs 25,000.
Correct. So I'm coming to that. Should we give me a minute? So these two properties, I get 31,87,500 in respect to the first property. I get 10,62,500 in respect to the second property. So these two amounts aggregate to 42,50,000 rupees.
No, just come to page 3. Of the impugned judgment, that gives the amount.
Yes, Milord.
You had received 1 crore 97 lakhs 25,000 in part payment, and the balance amount was 5 crore 91 lakhs 75,000. That was to be paid at the time of completion of the deed. Now, thereafter, come to the next paragraph.
Yes.
Paragraph 3.
Yes, Milord.
Read that paragraph.
The said premises was mortgaged on account of a loan taken by the appellants from State Bank of India. And the original title deeds was deposited with SBI as collateral security for the loan availed of by the appellants. In the agreements for sale, the appellants were required to obtain a no objection certificate within the stipulated period. This did not happen, as a result of which, pursuant to the minutes of a meeting between the appellants and PCL on October 25, 2011, the appellants handed over possession of the said premises in question to PCL on November 21, 2011. And on the other hand, PCL was required to keep the balance sale consideration of rupees 5 crore 91 lakh 75,000 in a fixed deposit with SBI till such time the appellants obtain a no objection certificate.
So that this deposit of 5 crores 91 lakhs has been made with
was created by Pan Card Clubs Limited, and then not subsequently.
So the entire consideration, as well. 1 minute, please, Mr. Jha. Let's not. The facts are facts. You can't argue against facts.
Absolutely not.
You can argue on law, but not on facts.
No.
So as far as the Pan Card India is limited, they have paid the entire sale consideration. They are out of pocket from that.
It did not happen, Lord. There is story further. Now this 5 crore 91 lakhs, the balance amount for which they were supposed to create an FDR. That FDR was created by them. It was kept with State Bank of India. But then there are ultimately what happened after over a period of time, they withdrew this amount surreptitiously from SBI. Now, thereafter, SBI remained high and dry. SBI then filed initiated proceedings under SARFAESI. Then they took.
Because what is the total loan amount? What is the total loan amount?
Total loan amount is a different story. But
1 minute, please.
Yeah.
It's not a different story.
Correct.
It's connected with it.
Not the,
They will not, please, Mr. Bha, they will not release the documents of pay, the documents for mortgage till the total loan amount is paid. It's not a different story. It's connected with it. Let's not go into that.
No, I'm coming to that.
Because they are not concerned how much money you have received, from what source you have received that money. They are not concerned. Correct? As long as their total demand is not paid, they will not give the documents of paper.
Absolutely.
Because even if they get 5 crore 91, if the total demand is 34 crores, they will not pay that.
The settlement, the OTS was for 6.40 crores.
Correct. That's between you and the bank.
Correct. So we made the balance payment 5.91 crores.
Mr. Jha, did you obtain any degree of the court for getting back possession?
I'm coming to that, Lord.
Please answer that.
But no, I'm not required to do that. But not section.
You can move in any time.
I'm sorry.
Anybody giving possession of the property, you can move in any time.
Kindly, Lord.
Are you arguing that?
From at least 5 decades.
Mr. Jha, are you arguing that you can move into property you given?
But then, Lord, we will have.
Anytime?
Your Lordship will go to that, my Lord. Who took the possession? The possession was not taken by SEBI. It was only remain on paper. The property was in possession of some third party For all these years, 10 years, it remained in their possession. We ultimately, my lord, when SEBI, my lord, came out with this defense, they have got nothing to do with the property. We sent a legal notice to the company which was illegal in possession for all these years, and the monies were collected. Lord, we do not know, because there is simultaneous attachment of under MPID Act. So who would collect the money? Whether PAN card would collect the money, or Lord, what happened to those monies collected from the company which was in possession? We do not know. We sent them a legal notice that how do you remain in possession of the property, because SEBI is no more interested in the property. We are the owner of the property. Now, only for a minute, before I go to your Lordship, to that aspect of the matter, just give me 2 or 3 minutes, Lord. What happened thereafter? Now, 6.40 crores rupees since 5.90 crores of rupees of FDR, which was created with State Bank of India, was surreptitiously withdrawn from State Bank of India. That FDR was broken. Ultimately, SBI then embarked upon to take action, physical possession of the property. They took even possession of the property. Not only that, they filed an application under Section 14(1) of SARFAESI Act in the court of the Chief Metropolitan Magistrate in Mumbai. And then the Chief Metropolitan Magistrate obtains an order under subsection 2 of Section 14 of SARFAESI Act. And then they were in the process of taking over possession. It was advertised in the newspaper, publication, everything was done of auctioning the property. At that point of a time, Lord, we once again approached State Bank of India and told them that now we don't want our property to go from our hands, because all that we received.
Mr. Jha, all these arguments have no water to stand.
I'm just coming.
Just absolutely baseless.
I'm coming.
For the simple reason, agreement to sell remains. To possession with
MPID court, my lord,
will remain. You will not be able to take possession. Forget about the income tax provisions, which have been referred to in the judgment in detail. There's absolutely no, you cannot go take possession on your, even if you settle with the State Bank of India, the possession will remain that of PAN card.
Just kindly bear with me, just 2 or 3
this
minutes.
This, if we are going to accept such pleas in the court, then what's going to, and arguments of this nature, then what's going to happen to rule of law?
Let me.
It's complete mockery of that.
Everyone lost sight of the fact that Section 53A of Transfer of Property Act is not a, well, this court has held way back in 1977. It is not a sheet.
Yes, it's a shield to protect their possession.
Correct.
And number 2, there are also judgments of this court which say even if a suit for specific performance is dismissed,
Coming to all
53A protections will still continue.
As to what is the position? The position is not Section 53A, a reference of which has been made by SEBI and also made by SAT. Lord, I am before the first court of appeal, my lord.
You're not. This is the second court of appeal on substantial question of law.
Respect, my lord.
Sorry, you're not in the first court.
After SAT's order, my lord, it is a statutory appeal.
No, sorry, it's a substantial question of law. Please,
you
don't have to tell us that.
Please see the legal position. So Section 53A decides interstate dispute or controversy between the seller and the purchaser. It is meant for that. It is certainly does not seek to resolve
Mr. Jha,
the dispute in any
the order is correct.
See Section 54, with which we are concerned with.
Not required. 53A will come in your way.
With respect, no, please see.
No, Mr. Jha, nothing doing. Please give back position immediately. Give back position immediately.
May I say this, my lord? If your lordship, kindly only for a minute.
No, Mr. Jha, nothing doing. Nothing doing.
Permit me to show to your lordship one judgment of this court, my lord.
Please, nothing doing. You give back position.
Lord, to whom the possession?
SEBI will take the position now.
Lord, MPID court will take, my lord. MPID court has to take the, and they have to move an application.
Whoever's the right with regard to that PAN card,
May I say?
let the money be paid.
Lord, may I say this? Just give me a few minutes, Lord, because ultimately my property cannot go to.
File a civil suit. File a civil suit.
And for 15 years I have been fighting this litigation.
File a civil suit.
But Lord, I am not required to do that.
Look, what's going to happen is MPID court will sell the rights as a assignee, assign the rights under the agreement to sell.
So Lord, that is what Lord MPID court did. MPID court, the public prosecutor made a statement that you received. Only for a minute.
You have done enough damage to yourself by not following the law. You should not have taken possession. You should not have taken possession.
But what I supposed to do? The property was abandoned after I.
Oh, no, please. You don't, nobody abandons the property like this.
Please.
Yes, very convenient for you to say that.
Please see the.
Please.
Please.
The company may have gone into bad
I wrote to
bad days, but that's all.
SEBI, I wrote to police, I wrote to everyone in 2023 that look here the.
That's very strange. These are all documents these are all legal documents prepared for your legal act.
To answer that, no, the possession is with.
Please, now go to the civil court. That will be decided in the civil court.
I have been, kindly bear with me, just kindly bear with me. Now please see, how many more years I should be fighting for this.
You should have fought. You should not have done what you have done.
But
you should have gone to the civil court. You may have won over there. Whatever would have happened would have happened.
See, this court has held that it is SEBI who will be required to go to civil court in a situation.
No, please.
It's a direct judgment of justice.
Sorry, please. Every fact. God, please don't. We also know the law. We also we are fairly familiar with law. And let's be. We also know when facts are requiring. When facts require, we ask SEBI to go. When facts require, otherwise we'll ask the party to go.
Please kindly see, my lord.
Omnibus statement, every case they must go.
Signed against me.
No, we have, look, please, the facts are, no, we have heard you.
No, with respect, my lord. Nobody heard me, nobody, my lord, tries to find out what is the position. Let us see section 28 of A of SEBI. 28 of SEBI Act or Income Tax Act to which reference has been made is not meant for me. It is as against a defaulter. Now, agreement for sale, kindly see, and that's the crux of the matter. An agreement for sale, and there is no controversy on this, does not create any right, title, or interest in favor.
53A creates a right.
53A is not come into the play. Will your lordship kindly see, my lord? Let us see, my lord, 77 judgment of this court. Your lordship will see this, my lord, and this is a judgment by 3-judge bench.
That will have to be decided by the civil court. As far as their position is concerned, you could not have taken possession. Your claim, sorry, Ms. Bachar, your claim that the property was abandoned. Sorry, you made it look abandoned.
Lord,
can't do that.
May I say this, my lord? Let them make a statement. Let anybody, either.
We are. It's quite apparent. Why should I require a statement for what?
Possession not taken by them. Anybody.
You delivered possession. You delivered possession to PCN.
Yes.
On 21st November 2011. How do you come back into possession?
I came back in possession because possession was supposed to have been gone either to SEBI or to MPID.
How did you take possession?
The MPID court also, my lord. The application is pending. While that application is pending, they take possession, my lord. Because after your lordship issued notice on the appeal, no stay was given. Yet they move in. And the MPID court, they moved.
I come in possession.
It's very unfortunate, my lord.
With respect, my lord. Your lordship will kindly see, my lord. This is not the. There is
after having moved the court, my lord, they could not have done it. That's my humble submission.
Did you take possession after the appeal was pending in this court?
1 second, my lord.
Answer that question. Straightforward answer. Simple, straight question. Simple, straight answer.
I took possession in the month of August 2023. I did not take possession when the property was abandoned.
1 minute, please.
I write to.
Okay, fine. Then you please abandon the abandoned property and move out. That's it. Please abandon the abandoned property and move out by next week. So please, we'll see that. We will see that. Please move out of the property immediately. Your property, that will be decided in the civil court. But please abandon the abandoned property immediately.
With respect, your lordship will kindly bear with me for 2-3 issues which arises for lordship's consideration.
Mr. Jha, did you take possession of the property when the appeal was pending?
Because
17th April, your lordship issued notice. In August, they take possession, my lord. After having moved the MPID court.
They have to answer.
Please, the order of SEBI was already there.
Yes.
Please.
Attachment was there.
Mr. Jha, please move out of the property within 1 week. We'll see, we'll take it up. No, Mr. Jha, it's for us to decide that, not for you. I'm sorry, that's for us to decide. What sort of consideration it requires. We can pass a speaking order just now and say, point out your misdeeds and why you're not entitled to any relief.
Will your lordship not consider this, my lord, that section 28A, let us see what section 28A. Let us see the provisions of Income Tax Act. Who would know?
So please, we are not required to go into all that. you are violated, when your appeal was pending, you suo moto went into the possession of the property, that's not acceptable.
No, my lord, I went, if your lordship could kindly.
Why did you enter the property?
Because the company Panoramic, which was in possession for all these years, they continued to in possession. When we sent them a legal notice, they, one fine morning, when my staff visits the premises, he finds that.
That's very straight, please, Mr. It's not so, we also know what happens. We also know what happened.
No, please see, my lord. So,
Please, Mr. Jha, please vacate the property within 10 days. That's all. We're passing it. We'll take it up after that. First, vacate the property. Everything has to be, and deposit the keys in the court.
Lordship.
my lord, may I say this, my lord? May I say this? I will do that. Your lordship may give me time of about 3 weeks, and your lordship may hear me.
3 weeks?
We have heard you substantially, but first deposit the keys.
I'll do that. I'll do that. I'll bow down before the court. But my lord, this issue, my lord, with respect, my lord, will have to be.
No, Mr. Jha, we'll hear. Mr. Jha, we've got no difficulty. You also know, we also know what is the law. It's not that we don't know. 53A rights, we know very well how they operate. We also understand. And what has happened is taking the law into your own hands, because you are aware now, if the property is sold because of the deposit of that amount, your property goes out of your hands, and therefore the values have gone up, and now you want to take advantage of it.
I don't want this, my lord. Property.
Okay, fine.
5 crores and odd amount which was kept with state.
Okay, can we record that statement? We can do that.
Yes.
Well, okay, 5 crores is 73.
5 crore 9 lakhs rupees of the FDR which they had created. It was to bear interest of 8.25%. Let them give me money. I will go.
That what has happened to that FDR?
There, my lord, the PAN card has gone into IRP.
What has happened to the FDR of 5.93 crores?
The IRP will be able to answer that, my lord. He's also a party.
IRP?
What we understand is that, my lord, that FDR was broken because they had to give an NOC. They were not settling with the bank. So I can take instruction.
The amount was taken back by PAN card, or it was taken away by the SBI?
We'll have to
buy PAN card.
The IRP
PAN
will have
card
to.
withdrew that money.
That's correct.
PAN card withdrew that money.
That's what I understand. But I'll
No, my lord.
instruction-
Let the IRP answer that, my lord.
Let ARP answer.
Then they may be justified in asking that you pay that, you sell that property, from that proceeds, pay them that, rest you can use.
That will be done, my lord. That will be done. But, my lord,
That money has to be paid to.
yes, but the possession has to be given to the MPID code in the
Yes.
first instance, my lord.
That position has to be.
Yes,
I'll take instructions from IRP.
Take instructions, we can put the property on the block,
Yes.
and thereafter, whatever amount, if it is, whatever
It is
amount,
due to them, my lord. It
that
has
will
to
go to them.
Yes.
8.5 or whatever 8% interest can go to them, and you get your property.
Lordship.
You sell whatever the proceeds are left.
Lordship.
That will be fair. That will be the.
May I say this, my lord? Your lordship may pass an order. I'm happy with if I get my money back. Let it come to me, my lord, with whatever interest.
Okay, wait. First, you give the position.
Yes.
Right now. Possession of the property. Bearing numbers. Property, subject matter property at Mahim, Mumbai. Shall be handed over by deposit, shall be handed over to the court by deposit of the keys in the court itself within a period of 3 working weeks, 3 weeks from today.
Consider 4 weeks. my
No,
lord.
3 weeks. You asked for 3 weeks?
No, I have
We said
two
10.
more,
We said 10. You asked for
I have my office operating from there. There are other offices also operating from there. They will have to be accommodated.
within 4 weeks from today by deposit of keys in the court. In this court,
In this corner.
to this court, and by deposit of keys also in this court. Full stop. In case possession is not given within 4 weeks, the appellant will be liable to pay. How much is the rent being received?
No, I'm operating myself.
We don't know. We'll have to
Yeah,
verify.
we will do it. Lord,
No, I have to do that.
the director of the
No,
company
no.
is present in the court.
No.
I will remain present, Lord, after 4 weeks.
Then they will be liable to pay the appellant would be, in addition to contempt, would be liable to pay mean profit from the date they have taken possession of the property. Full stop. Relist in the week commencing 20th of January 2025. In the meanwhile, just take instructions whether the amount
Exact
of
amount.
5 crores ought what withdrawn.
Yes.
Better way will be that we put the property on block, sell it off. Whatever amount is payable to him
Yes,
on that 5 crores in odd,
Lordship.
along with interest, can be paid to him. Rest of the amount, the interest was, just check up whether the interest limit, etc., was paid also, or it got adjusted towards the dues of.
Lordship.
No, it was not. They took up the money, entire money. There is a certificate annexed to the proceed. Lord, may I only say something? If your lordship could be kind enough, Lord. Lord, please mention, Lord, any lordship's order, if your lordship so speaks.
We all remember.
Lord, the property is attached in the MPID code, so perhaps we have to.
Pardon?
No, there is
the
not.
property.
No, not now.
No.
Not now. That mortgage has been redeemed.
So every order, this
That
order.
mortgage has been redeemed. As
No,
per
my lord.
my understanding, the
No.
mortgage is.
What happened is, my lord, amount has been paid by PAN cards towards the purchase. That amount they have with it. When we asked them for the return of that money, they said, no, you have no right because the matter is pending in IBC.
No, 1 minute.
Yes, 1 crore 97.
The 1 crore 97 has been paid by.
Paid, Lord,
There is
yes.
no difficulty, but
Paid by PAN card.
paid by PAN
Yes.
card. The other amount of 5 crores and odd has not been paid.
No, my lord. That was deposited. I'll check the position because the IRP will be in a position to.
So we want to verify
Yes, ma'am.
that fact.
Yes,
What you have,
lordship.
if you sell the property,
Yes, please,
you
your
can say out of the sale proceed,
Speak
you
away.
get your 197
Yes, ma'am.
plus whatever in is
Lordship.
accrual or the benefit of enhancement in property, increase in property prices have taken
Lordship.
place. They don't get the benefit of the enhancement of property prices. They get that 5 point something along with 8% interest.
Lordship.
That will
Please,
be beneficial for the
Both. Yes.
both of them.
Yes.
That will sort out the matter.
Lordship, please.
Lord, it can be lost sight of, Lord, if your lordship could say.
No, Mrs. Jha, it's not so. Our memories is not so.
No, absolutely.
You probably couldn't get a. You came last week. Today we were quite firm on you.
Memory is very strong, Lord, that is what. Deep reflection.
May I please, my lord? My lord, on last date of hearing, my lord
You have to respond.
specifically asked whether respondent is staying in the suit property or not. I have filed additional documents. It is an admittance case that they are not staying there.
And we have also filed an appeal.
solution found.
But we have offered him a flat, my lord. She doesn't want to shift, my lord. From the very first court onwards, the trial.
How big is the flat?
But about 700 square feet. She is occupying one room.
Your flat is how big?
Flat is one room along with kitchen and there's also the dining space.
And she's occupying one room.
Just one room.
And the kitchen and the dining space is with you. But you cannot occupy because you can't stay together because there's
But we stay, but not for long. If we stay for long, well, there will be further criminal cases. Already criminal cases have been filed, they are pending, they are yet to be settled. We, from the very first court, the trial judge, the first appellate court, high court, all tried for settlement because of this sibling issue,
You are not also ready to shift?
No, difficulty is that now presently I'm 70 years old.
But you earlier agreed to shift. They gave you the property. You come back again and say, I'm not ready to shift.
No.
Look, let's be very clear.
My difficulty
Just
is
1
that
minute, please.
I
Your
may not
difficulty-
need big
No,
house.
don't look at your difficulty. Look at the difficulty objectively. If you look at your difficulty, if you look at only 1 minute, please. If you look at your difficulty, it will not work out. Look at the difficulty of the other side.
Well, that's why.
1 minute, please. The fact of the matter is you got married. Correct? Now the issue would be, and the courts have repeatedly held, once you got married, your right to stay in the will came to an end.
Well, that is on merit. I'll address
1 minute, please.
merit because
Wait, that's been held repeatedly against you.
yes, but
One. Number
Yes,
two.
well,
Number two. There is an obligation of the brothers to maintain you. In pursuant to that obligation, they are ready to give you accommodation, alternative accommodation. You also agree to that alternative accommodation, but somewhere when your mind changes and you say, I will not go to that accommodation.
May I submit? Well, Lord, at this stage, I am suffering from various ailments. I may not need the big house because I want to stay here because my brother.
That is sorry.
Some
look, please.
Neighbor, they will be helping me in my.
No, 1 minute, please. There's a problem. There's a problem.
If I move to unknown place, how I'll
provide someone.
Other rooms are locked.
Property.
More than 2 kilometers. It's complete different area. 2 kilometers.
Then to provide it attendant if you want. Give you about 10,000 rupees a month to be able to have.
My lord, other rooms are locked. I am only occupying one room.
But
even terraces.
The reason, please, let's not go into all that. The reason why the rooms are unlocked is because whenever they come over here, there's a police case. How many police cases are there?
Only domestic violence case is pending.
Look, please, nobody, the children don't want to shift there. The children are not ready to shift there because they say that we cannot stay.
They have full-fledged flat.
Look,
they are staying there.
We can do, we can ask them to pay you 10,000 rupees a month along with the other property.
No, my lord, other property is far away. My lord,
whatever 2 kilometers is not very far.
One room may not create problem for me. More problem is for me that I cannot move to new area.
No, please, we cannot.
I am there since 1976. At this age, I don't have any relatives.
We can only help you. We can only help you to the extent we can.
Neighbors will help me in day-to-day.
Please, no.
Attendant.
Then I have alternate another proposal. If they are staying in that flat, they want to shift here. That flat is very near to this suit property. Then I may be shifted to that flat.
What do you say on that?
Well, then I have to take instruction, my lord. And furthermore, subject to correction by my lord, so far as the 3 courts have held, my lord, so far as maintenance part is concerned, it was if she remained unmarried. Once she has...
God, there will be little...
Section
you have to be little... you'll have to also understand she's your sister.
Married lady is entitled to maintenance.
On merit, my lord, this document itself should be actually...
She's not cut off her ties from you. She's not cut off your ties. Don't look, we have to find this a problem. We are not in agreement that she should stay here. We are with you on that because there's so much acrimony and Whatever happens is they cannot, children are, you are right, your children are not ready to come and stay with her. So we'll ask her to move out. She's insisting, we're not agreeing to that. But you get her accommodation, pay her 10,000 rupees a month, whatever it is. It's something which you'll be doing good for your own sister. You're not giving it to some, in fact, it's not even charity.
Difficulties, my lord, so far as the flat is concerned, my lord, from 2011 we have been trying. Now, my lord, the prices are soaring. Now, my lord, the prices has gone high up, my lord.
So that benefit comes to you.
Yes.
But
You can sell it also. We are not restraining you from selling it. You may not sell it, you may sell it. It's for you to decide.
no, so far as this is ancestral property, my lord, we want to stay, my lord.
So it's fine with us. There's no difficulty.
Then I
then
will
I
permitted to
come
move
back with
their
instruction.
flat.
You just take instructions, come back on that, give her the flat, let's pay her 10,000 rupees a month. Let it be. Because after all, there has to be some, she's alone, there's nobody to look after.
But we have all sympathies, my lord. But if in the first court it was settled, it was being
Then show that in monetary terms.
My lord, kindly see that even that deed itself protected me, my lord.
No,
Yes.
no. It's
from
not.
the very first.
You'll have to move out. That we are very clear. You move out. That we are very clear. On that we will not come.
My lord, then I'll shift to their flat. Or
No. You can't insist on that. Whatever they
My
can.
lord, that is far.
1 minute, please. We can ask them if they don't want. They don't want problems. They have.
How I'll
We
mention.
have understood that. We are taking.
And
We
my
are.
lord, even my
Look,
lord,
they may not like you in their property. That's
even my lord settlement deed says how father protected every aspect that
we have,
even
look, by going by what is there,
See
we
page,
can simply dismiss
42
your
for a
appeal.
moment.
We can simply dismiss your appeal because they concurrent.
My lord, only point and
Sorry, do not
Valid
keep on
appeal-
going back on that. We are not agreeable to that.
marriage cannot act as
But
eclipse. That is the
we
point, my lord.
We tried our best all these years. my lord.
Please, just take instructions whether you can, two aspects, whether you can ready to give that other flat to to reside, one room in there, or number two, in case that is not possible, any other place within the radius of about 2 kilometers or 3 kilometers, plus
It's
10,000.
1 kilometer because
Sorry, please.
my lord, they are
Do not now.
my lord, why
Sir,
I'm
may I
saying
come
that?
back at 2 p.m. my
2
lord?
kilometers. You can come at 2 p.m.
My-
Come at 2 p.m.
May it please the Lordship. Your Lordship, on the last date of hearing, Your Lordship has directed to take instruction with respect to the execution and possession of the petitioner, Your Lordship. I have to take instruction on that aspect, Your Lordship. I'm praying for a 2 weeks time because the suit was only for possession. And when this Honorable I'll take instruction, Your Lordship.
Why did you not?
Only a week's time, Your Lordship.
Did you not take instructions? Why should the matter be adjourned?
Your Lordship,
It was passed in September.
yes.
We're dismissing it then. We'll dismiss it.
I'm sorry.
We'll dismiss it then.
Your Lordship, I'll argue on merits of the case, Your Lordship. Your Lordship, in this case, the suit was filed by the plaintiff and for the defendant. The suit was filed on the ground that there is a relationship of landlord and tenant, and because the petitioner was not handing over the possession, therefore the possession should be handed over to the plaintiff. That was the suit. The possession was claimed on the basis of the relationship of landlord and tenant.
Now, when the trial court, Your Lordship, dismissed the suit, the learned trial court came to the finding that the plaintiff has not been able to prove that there was a relationship of landlord and tenant. This has not been proved. There is a specific finding of the trial court. And since the relationship of landlord and tenant is not established, therefore the plaintiff is not entitled to take possession. And the appeal was filed by the plaintiff before the learned appellate court. The appellate court came to the conclusion that it is an admitted fact that the plaintiff is the owner of the property. So far as the finding on the landlord and tenant dispute is concerned, Your Lordship, no finding was given.
Not required.
Then,
Not required.
then Your Lordship,
Under the rent control legislations, in fact, owner is always treated as a landlord.
Your Lordship, but there is.
Who will you occupy a property?
Yes, Your Lordship, as per the case of the defendant, Your Lordship, the plaintiff had to sell the property to the defendant for which 90,000 was given. This fact has been admitted. There is no dispute on that aspect.
What is the date when he came into possession?
I'm sorry, Your Lordship.
What is the date when he came into possession?
Your Lordship.
And there is no agreement to sell.
There is no agreement to sell. That is the finding of the first appellate court. The first appellate court came to the findings that since there is no agreement.
What is the date of payment?
Date of the payment, Your Lordship.
Is it by check?
No, Your Lordship. There were two payments. Your Lordship, so far as the payment part is concerned, there is no dispute
What
on
is the date
even
of payment?
Yes, I'll just point out, Your Lordship.
See, payments are sometimes maybe.
Your Lordship, may kindly turn to page 32.
Yes.
That is my written statement, Your Lordship.
Yes.
The content of para 2 of the plaint that the questioned property and field was given to the plaintiff by registered till deed is not within the knowledge that the reply is not possible. Rest of the content of the para of the plaint that the questioned house and field presently belongs to the plaintiff is denied being incorrectly. The correct statement is that the questioned house and field was purchased by the
defendant. Did you take benefit? You did not take the plea of 53A?
Yes, Your Lordship. No, Your Lordship, my only submission is this, Your Lordship.
You have to lead evidence on
Yes.
that.
Your
You have
Lordship,
not laid evidence on that.
Your Lordship, agree, Your Lordship. What my limited point is.
And were you making periodical payments to him also?
No, Your Lordship.
You never made any payment?
There is.
When was the suit filed?
The suit was filed on, Your Lordship. The suit was filed on 11/5/2003.
8.
I'm sorry, Your Lordship.
11/5/2008?
2003.
3. Sorry.
Your Lordship, only one submission if I make, Your Lordship. Now it is an admitted fact. The learned first appellate court has also admitted fact that 90,000 was paid to the plaintiff by the defendant. When the appeal was filed before the Honorable High Court, so far as the possession part is concerned, Your Lordship, the first appellate court did not upset the finding of the trial court that the relationship of landlord and tenant has not been established. But even then, merely on the ground that the plaintiff is the owner, the learned first appellate
interfere in 136.
Now, Your Lordship, the Honorable High Court has
not the owner. You accept he is the owner. Why should we interfere? Right.
Your Lordship, because
we are not inclined to interfere with him.
Because, Your Lordship, the point is the suit was based only on the premises.
We have understood. Please, we have understood. He is the owner. Please give him possession. That's it. Why should we interfere in 136?
Your Lordship, so far as the possession part is claimed, Your Lordship, it is claimed only on the basis that there is a relationship.
We have understood your argument, but we are not inclined to interfere in 136. We are not inclined to interfere with the impugned judgment, and especially petition is dismissed.
This appeal comes up after notice, my lord. And your lordship, notice was issued in 2022. Your lordship, by order dated 8/12/2023, directed the CEC to inspect the mine of the petitioner. That report has come, my lord.
2/8.
Sorry, CEC report objections.
2/8/2022, we had issued notice.
Lordship had issued notice.
Subject to deposit of rupees 2 crores.
That was done, my lord. That is recorded in the order dated, my lord. The 11/11/2022. 8/12/2022. Sorry, my lord.
That payment has been made.
It was the monies were paid, my lord, deposited on 12/8/2022 and 11/11/22 in two.
That's fine. That's fine. That's fine.
And my lord,
now let's come to the impugned judgment.
Sorry, my lord.
Let's come to the impugned judgment.
Yes, my lord. So, my lord, yeah, the CEC report, my lord, is in my favor, in my respectful submission. The Central Empowered Committee report has come on 27 September 2024.
27 September
2024. They had asked for extension, my lord. Your lordship permitted that extension, and thereafter it has come, my lord. So, if I may just outline what is the case, my lord, here. I was given an LOI for sand mining, my lord, on an area of 36 acres in UP, my lord, Saharanpur. Thereafter, my lord, after taking all the permissions, the agreement, the mining lease was signed only in 2021.
But what is the date of signing of the mining agreement? What's the date of signing of?
Sorry, my lord, I'm just taking out my list. Sorry, just give me one moment. The mining lease is executed on 1/4/2021.
1/4
2021. After, my lord, all the permissions that were required were granted, my lord. Of course, the LOI, as I mentioned, my lord, is of 30/12/2019. Was after a tender, my lord. I was the highest bidder in the tender.
2019.
30/12/2019.
Yes.
Now, my lord, after I started operating, my lord, the respondent number 10 herein filed a, my lord, petition challenging the environment clearance granted to me.
Yes.
And thereafter, my lord, the matter was heard, my lord, and the NGT formed a joint committee. Joint committee gave a report that I was extracting more sand than the daily limit. That was one. Secondly, my lord, that there was no consent to operate or establish so far as the pollution is concerned, and about water extraction. So, my lord, the NGT has in its order.
The more sand than was the daily limit. Second was?
Yes. The second was, my lord, regarding the consent to establish and operate. And the third was, my lord, unauthorized usage of water. And there was also a, my lord, minor thing about that whether I am in a cluster mine within 500 meters, which of course, my lord, concurrently was found even by the joint committee that it was not cluster mining. So therefore, my lord, there was a fine imposed on me by the NGT.
Of how much?
My lord, the amount was, my lord, that for the mining in excess of the daily limit, it's 10 crore 91 lakhs 10,840. Or operating without consent to operate and consent to establish.
Yes.
8,40,000. And unauthorized water usage was 1 lakh.
Yes, please.
Lord, we came to your lordship, my lord. And
you're challenging the fine both on merits as well as quantum.
Please, my lord. My lord, the CEC report says that there is no illegality about the quantum of sand which has been extracted because there is no daily limit. So the very fine foundation that the extraction.
Let's see the finding in the impugn judgment as well as the CEC report.
Your lordship will kindly come to, my lord. If your lordship just see, my lord, the report which starts, my lord, the joint committee report.
No, first let's look at the finding in the impugn judgment.
The finding, my lord, is at page number 15. It starts paragraph 7. It, my lord, just accepts the report.
Let's see the report, first report.
Sorry, my lord.
Let's read the portion of the first report, joint committee report.
Yes, my lord. The report, my lord, starts at page number 2. At the foot of the page, the joint committee, the findings of the committee are.
Yes.
And then your lordship will come straight away to page number page number 3,
Yes.
paragraph 6.3.
Yes.
The lessee had started mining after getting EC permission, getting EC from the SEIA and permission from the mining department. During the visit, the project proponent representative stated sand excavation has been started on 4/4 and mining work has been stopped on 36. Permission for mining has been granted by the mining department on 1/4/21. Mine proponent has sold the material till 36/21 and it was informed that the mine was operated for 84 days, during which 3,77,748 cubic meters of sand, bajri boulders have been excavated. The weighing bridge has been installed for weighing the amount of excavated material. The data generated through the weighing system is being submitted on an online portal. As per the information provided by the project proponent, excavated material has been sold to the stone crusher for further processing. Material has been sold to 44 different parties. And then, my lord, the mining department inspected the mine twice during June 21 to verify the content of the complaint received to the district administration. The mine was found to be operational during the first inspection, whereas during the second inspection, the mining work was found to be closed. As per these inspection reports, excavation is being done through the machines and the depth of the excavation is about 2.8 meters. Now 6.5, the bold portion. The proponent has carried out mining operations without consent from UP Pollution Control Board. They have submitted the online application for seeking consent from UP Pollution Control Board on 17/6/21. Based on it, UP Pollution Board has issued a show cause notice to the mine on 9/9. Environmental compensation of rupees 7,70,000 is also proposed for the period of 77 days at the rate of 10,000 per day in accordance with the methodology developed by the Central Pollution Control Board. Then, my lord, your lordship will come straight away with reference to 6.6.6, my lord, on that very page 4, the second last, my lord.
Yes.
No operational mine was sited within a 500-meter distance from the said mine lease boundary. That is regarding the cluster mining.
Yes.
Then, my lord, over the page, your lordship will kindly come to clause 7. Number 7 rather. No, it's not
Yes.
clause, my lord. In the environmental permission, EC, my lord, granted, environmental consent it is, issued to the mine proponent, they are permitted for the production of 7,56,000 cubic meters per annum and 3,33,360 square meters per day. As per the undertaking given by the mine proponent, around 3,77,748 cubic meters of material have been excavated during the operational period. It was also informed that out of 91 days, that is during so and so, the mine production was kept closed for 7 days. Hence, mine production was carried out for only 84 days. The project proponent has also provided daily production details. As per this data, the quantity of daily production varies between 11 cubic meters to 9,194 cubic meters. The proponent has excavated excess than the prescribed daily production, that is 3,360 cubic meters during 62 operational days and excavated around 1,33,062 cubic meters excess quantity during those days. Thus, in total, they have excavated around 1,33,062 cubic meters excess material than the permitted quantity based on the daily limit.
Just read that again.
Sorry. Thus, 7.5 I am reading.
7.4.
7.4. The proponent.
Okay, read 7.3 onwards.
I'll read 7.3 also. The project proponent has also provided daily production details. As per this data, the quantity of daily production varies between 11 cubic meters to 9,194 cubic meters. The proponent has excavated excess than the prescribed daily production limit of, that is 3,360 cubic meters during 62 operational days and excavated around 1,33,062 cubic meters excess quantity during those days. Thus, in total, they have excavated.
So, what paragraph 7.4 says is a prescribed daily production limit of 3,360 cubic meters.
That is what has been found, that there is no such prescribed daily limit.
1 minute. And this, therefore, they multiplied by 62.
Yes, they have multiplied.
they multiplied by 62 and they came to the conclusion that you have
That
made-
10 lakh 80,000 has come on that basis, my lord. 10 crore 80 lakh.
correct.
So, my lord, the finding is that there is neither the EC nor the requirement in law is of any daily limit. There is the prescription is only of an annual limit. If you exceed that, my lord, here I have not even worked for 1 year at the time, only 2 months, my lord. April, May, and June, my lord, this is the time.
We should look at the environment clearance.
See,
Sorry, my lord.
That EC which is referred to,
84 days.
where is the EC?
that
Environment clearance.
because that says 7 lakh 56,000 metric tons annum and 3,360 metric tons.
What are not prescribed?
That is a calculation made by them, my lord. That,
So let's see.
Let us see the
Let's
EC.
see. Let's see the EC.
Yes, my lord. Your lordship will see this at volume number 2. Can I show it from the CEC report?
Let
It is
the
also
EC
next to the CEC report.
But I believe the EC will give more details also because they work out the daily limit on the basis of how many trucks, how many working days in a year.
No. First is whether there was any daily limit.
There was
discussed.
in EC and documents preceding EC, in EIA and report,
My
in
friend
terms of
wants to
reference.
argue first. I don't mind him arguing first. I can reply.
Which page is the
90.
EC?
My lord, if your lordships come to the CEC report.
Why don't you show us the EC, Mr. Rani?
Sorry, my lord.
EC,
EC, I have also filed.
which page?
What you want to see from my.
Well, it's 286 of
If
volume
your lordship see, my lord.
at 290.
If my friend doesn't mind, I think I can assist the court with all the pages. If he's a little anxious, my lord, I don't mind him arguing first. My lord, the 286, volume 2.
Yes.
26 March 2021, environmental clearance.
Yes.
Now, my lord, environment, if your lordship see, please refer to your application, etc. A presentation was made at 287 and the environment clearance is sought for such and such. My lord, salient features of the project are mentioned. Now, this proposal, which goes on, my lord, at page number, my lord, all the columns that are filled at, my lord, 290, your lordship will find at number 18.
Yes.
Number 18.
Yes.
Or 17 also.
Yes.
16 says total mineable reserve 7,67,814.
Right.
Total proposed production in the LOI is 7,56,000 per annum. Proposed production per year for 5 years is not mentioned at the rate of 7,56,000 cubic meters per annum. Now, if your lordships come to number 20, production of mine per day 3,360 cubic meters per day is mentioned in my proposal. Now, if your lordships come further, my lord, at 294, my lord, this is the form which I filled up. Your lordship will see that at serial number 4 at page 287. 287 number 4, salient features of the project as submitted by the project proponent.
This is your application.
This is what my
In your application, you had said that you will excavate about 3,360 cubic meters a day.
That's what that. Now, my lord, if your lordship will kindly come, the grant of it at page number 292.
There's no mention.
Last para.
Yes. Per annum is
292 last para. Sorry. Last para 292. Based on the recommendations of the state level expert appraisal committee meeting held on such and such. On the
Yes, 292.
292, my lord.
Yes. Yes.
Sir, my lord, my whole thing is extracted. Based on the recommendation of the state level expert appraisal committee meeting held on such and such on the above said project, the state level environment impact assessment authority meetings held on such and such has decided to grant the environment clearance to the title project for collection of 7,56,000 cubic meters per annum is the proposed lease area of 36 hectares, subject to effective implementation of the following general conditions and specific conditions. So, my lord, this is what was granted to me per annum. And then your lordship will.
That may be referring to the total amount, total quantum, but it doesn't obliterate that the requirement. that will meet the specific, will not exceed the specific sum per day.
For that, Milord, therefore, I want to show how the CEC has given a finding on this, Milord. The Central Empowered Committee, if your Lordships kindly have the report, Milord, dated 27 September 2024. And your Lordships will come straight away to page 31 first. Paragraph 30.
Yes.
Paragraph 30. Based on the findings of the Joint Committee and the order dated 10/5/22 of the Honorable NGT, the CEC felt that the following point became germane to the matter at hand and need to be examined in detail. My Lord, got that, Lord?
Which page are you referring?
Whether before the start of mining,
Which page?
sorry, page 31, paragraph 30 of the CEC report. Based on the finding of the Joint Committee and the order of the NGT, CEC felt the following point. Whether before the start of mining, consent to operate, consent to establish under the Air Act and Water Act is were required, whether mining was taking place within 500 meters of another existing mine and cluster certificate, whether groundwater extraction has been taken place without requisite NOC, whether any daily limit has been prescribed for sand mining by any authority, and if yes, whether the leaseholder has excavated excess mine material beyond the permitted quantity, whether all the conditions of the environment clearances, which inter alia included raising of plantation and installation of 4 ambient air quality monitoring stations, were complied with or not. This is, my Lord, the question now. Now, regarding state away for the daily limit, my Lord, your Lordships will kindly come to page number, my Lord, page 39 at the foot of the page, point D. I am taking your Lordship first there, my Lord, then I'll take you to the other portions. Page 39, foot of the page. Whether any daily limit has been prescribed for sand mining by any authority, and if yes, whether the leaseholder has excavated excess mined material beyond the permitted quantity. The Joint Committee has mentioned that during the entire period of mining in 84 days, the applicant exceeded the daily limit on 62 days, and thus there was an over extraction of 1,33,062 cubic meters of material beyond the permitted daily limit as specified in the environment clearance issued by the State Level Environment Impact Assessment Authority. It has also been noted by the Joint Committee that out of 91 days during 1st April 21 to 30th June, the mine production was kept closed for 7 days during so and so. Hence, mine production was carried out only for 84 days. The process of granting environment clearance starts with the application filed in the prescribed form before the competent authority. Now, my Lord, kindly mark this. Nowhere in the form, the applicant is required to fill any daily limit. Kindly mark this.
That is wrong.
Sorry.
That's factually wrong. We just did the form at 290.
So that format is what I have given, my consultant has given. It is not the format, my Lord. I can show the format, and the format is separately annexed. I can show that format. The appellant, and nowhere in the country, my Lord, it is so happening. I can, my Lord, I am saying so.
That's not there in any other.
No, nowhere. Nowhere.
Daily limit is not.
And now, in fact, my Lord, my instructions are that it has also been omitted.
It's there.
I will show, my Lord, your Lordship will read this, your Lordship will get this, my Lord. The appellant has shown a proposed capacity of mine per day that applicant has shown, I have shown. That is 3,360 cubic meters in the Environment Impact Assessment Report of the project. The EC granted by the State Level Environment Impact Assessment Authority to the appellant for the said mine on 26 March 21 mentions about protection of mine per day in point number 20 under the heading Salient Features of the project as submitted by the project proponent and not its conditions either general or specific. Hence, no condition of any daily production limit has been imposed by the State Level Environment Impact Assessment Authority while granting EC to the appellant for this mine. The form prescribed by the Ministry of Environment and Forest and Climate Change for the applicant for grant of EC in the extent case has no columns. Below annexure 22, I can show they have annexed it. Has no column where any daily limit is to be entered by such applicants. The Director Department of Mines and Geology, Government of Uttar Pradesh on 3/9/2024 submitted a letter dated 4th March 2022. The following has been clarified. The daily quantity of mining is mentioned in certain applications submitted by the project proposer for obtaining an environmental clearance certificate of mining area, but the quantum of annual mining is prescribed in the environment clearance certificate issued to the applicant. It is worth mentioning that according to the notification issued by the Ministry of Environment, Forest and Climate Change, mining work is prohibited in the monsoon season, July to September. In some mining leases, the remaining quantity is adjusted in other months of the lease year in view of the increase in the water level of the rivers or due to the order of the Honorable Court and other miscellaneous reasons. In view of the above, it is not possible to fix a uniform daily quantity in mining leases. Rule 2822 of the Uttar Pradesh Minor Mineral Concession Rules provide that amount payable for the first year will be determined by multiplying mineral quantity mentioned in the environment clearance certificate with the rate obtained in the e-tender/e-auction. Dividing the annual dues under the mining lease into monthly installments, except the monsoon period, is determined according to the 5th schedule under the Rule 2824 of the Uttar Pradesh Minor Mineral Concession Rules. There is no provision to fix the daily quantity of mining in the rules of 2021. The District Survey Report of 4/9/2019, tender notification of 1/11/2019, issued prior to the tender being awarded to the appellant, letter of intent dated 30/12/19, approval of the mining plan on 13/3/20, public notice dated 16/9/20, mining lease dated 1/4/21, mention only about the annual quantity to be mined as 7,56,000 cubic meters per annum. There is no mention of the daily prescribed quantity of extraction in any of these documents. The member secretary UP Pollution Control Board was called to the CEC on 15th February 24 and by letter dated 19th February, it has been submitted that the project proponent himself proposed that the production of mine will be 3,360 cubic meters per day as per the point number 20 of attached environment clearance. Accordingly, the project proponent was granted environment clearance by the SEII on 26 March for collection extraction of 7,56,000 cubic meters per annum. The Joint Committee concluded that the proponent has excavated excess than the prescribed daily production during 62 operational days and excavated around 1,33,062 cubic meters excess quantity during those days. Thus, in total, they have excavated around 1,33,062 cubic meters of excess material than permitted. Here it is worth noting that nowhere in any of the conditions of the environment clearance, any daily limit has been prescribed. Hence, calling it as a prescribed daily limit is not correct. The Director of Department of Mines and Geology, Government of Uttar Pradesh, on 3rd September 24 also submitted a letter dated 11/7/2017 regarding the provision of EMM 11 forms for transport of mineral. The Director, during discussions of 3/9/2024, mentioned that EMM 11 forms are issued electronically and no daily limit is considered for them. So even for transport, and permission to transport, for this only the annual limit is sacrosanct, and once the annual limit is reached, no further EMM 11 can be issued to any miner. In this case also, EMM 11 has been regularly issued to the appellant without considering any daily limit. Details of such EMM 11 issued during the period of inquiry are on page 261 of this report. The District Magistrate of Saharanpur, in his letter dated 2nd February 23, addressed to the Director Environment, has specifically mentioned that there is no provision for fixing daily limits of mining under the relevant rules. The UP Minor Mineral Concession Rule 21 make no provision for the quantity of daily extraction to be fixed. There is also no notification issued by the Ministry prescribing that any daily limit of mineral has to be extracted. Even in other mining projects that are evaluated by the appraisal committee of the central government, which include bigger mining projects having more environmental impacts.
Yes, what you saying?
And then we got over the page. So, and
anything else? Yeah, there is no prescription in the form itself.
Form is Annexure 22. Your Lordship may see that here. It is they have annexed it in the CEC report, and it is at page number 413. 413. Kindly come to 413, Milord. Application. This is Form 2, application for prior environmental clearance. Milord, first is details, second is address, 3 is category of project, then 4th is location of project, Over the page, number 5 is whether project is executed in multiple states. 6, details of the terms of reference. 7, details of public consultation. Then 8, details of project configuration, product, multiple entries allowed. Then, my lord, if your lordship see product, below that, my lord, your lordship will kindly see in small letters, unit, tons per annum, megawatt, hectares, kiloliters per day, tons crushed per day, cubic meter per day.
Yeah, but it's requirement of cubic meters per day here.
About crushing. This is about crushing, my lord. Mode of transport of transmission of product, so and so, so and so, so and so. So your lordship.
Where do we get it for crushing?
My lord, if your lordship see project configuration.
No, it says details of project configuration product. Multiple entries are allowed.
Multiple entries means, my lord, it just.
There are different products, you can have different entries.
So whether
but this is not for
then
this.
Project configuration, plant, equipment, facility, configuration, remark, product, activity, capacity, area, quantity.
This is with regard to product. C is with regard to product. So sand will be a product. Sand will be a product.
No, sand will be a product, my lord. Sand is it's a mining.
Yes.
According to me, my lord, it comes in a different mining. If your lordship see,
generic form.
My friend, it informs me this is a generic form for all industry.
That's fine, but here you have to give them the data with regard to that extent. The CEC is wrong.
No,
when they say daily limit is not to be prescribed, there's a reason for that. Let's put it. There's a reason for that. Sand accumulates over a passage of time, with period of time, because of the silting in the river, and therefore there has to be if you excavate too much, then the river can change the course and it can have its own problems.
Milord, my instructions are that this relates to cubic meter of crushing per day, not about extraction per day. This is the instructions are unit when it says tons per annum, megawatt. That's so, Milord, I come within the first one, tons per annum.
No, if you
megawatt,
then why not cubic meters per day then?
No, cubic meters is regarding crushing is what my instructions are, because nowhere in the country it is so granted.
Nowhere in the country is it so granted.
Other states ECs also I can show. I have annexed them as example, and I will show that none of them have it.
None of them have it per day.
I have annexed them, Milord, as example. If your lordship permit me, I will show that. So, Milord, then if your lordship will kindly see, number 9 talks of expansion only for coal mining. Then details to consent to operate is over the page. Then project cost. Note, project attract a specific condition specified in the EIA. General condition, specific condition, raw material, and then baseline data. And details of water requirement, groundwater table, waste water management, solid waste generation, air quality impact, present land use, ownership pattern, power requirement, land requirement, ecological and environmental sensitivity within 10 kilometers. That is for that wildlife thing, Lord. Forest land, tree cutting, land acquisition, rehabilitation, presence of Schedule 1 species. So therefore, Lord, in each of these columns, there is a generic thing which is mentioned. It's specific to, this is not specific to, Lord, any particular industry. Whether there is a presence of water body, manpower requirement, green belt.
So we have what we have received linked it now.
Mining plan is here.
My plan, Milord, is just give me one moment, Milord. 1 second. It is there, Milord. My
170.
179 of my paper book, Milord. $179. Okay. Milord, if your lordship see page 179, page 179 is the approval In the context of the above, it is to inform that the mining plan submitted by the leaseholder in respect of the area referred above has been approved on March 30, 2020.
The mining plan.
Where is the mining plan?
No, page 180 top, my lord, serial number A, if your lordship see in the approval.
No,
The
we
mining
want to
plan-
look at the mining plan itself.
Plan is not there.
Mr. Ranjit Singh, Rajit Kumar,
Please.
you turn to the form.
Yes.
Right? Yeah, because tons per annum will not apply.
Sorry, my lord.
Then in your case, tons per annum doesn't apply. What will apply is only cubic meter per day.
Cubic meters per day.
Yes. That will only thing which will apply to you. Tons per annum is something different.
Mine is, my lord, per cubic meters per annum.
Now, which
definition-
no, the only column which will apply to you is cubic meters per day.
No, my lord, with respect, the grant is on the basis of 7,56,000 cubic
Correct.
meters per annum.
1 minute. There are two ways to look at it. There can be, you can say, there can be an annual limit, there can be a daily limit, there can be even a periodic 3-monthly or 4-monthly limit. Everything is possible. You can't say mainly because the annual limit is fixed, then daily limit cannot be fixed. These are two separate things altogether. You can have an annual limit as well as daily limit.
May I just answer that?
Because let's also clear, sand cannot be excavated throughout the year. There are periods when there's.
So just wanting to say that.
It cannot be excavated.
If it can't be excavated during rainy season.
Correct.
You can't excavate.
But therefore, it's important to also fix daily limit. Now the finding, look, if column number 8 applies, if column number 8 in the plan applies, the EC requires you to give per cubic meter per day. If it is a requirement, it applies to you, then you have to give that.
The ministry is a party, my lord. The ministry can come forward.
Okay, we can ask them. Who's appealing for the ministry?
The CEC report shows otherwise. The ministry can inform, my lord, your lordship. The state of UP is also a party. They are also here, my lord.
And since this was a riverbed area.
Mining plan.
We don't have the mining plan.
Next lodges, but whatever has been given by the CR, their application and the application.
It must be.
The cubic per meter day is mentioned, lordship. In our lordships may have page 188.
188 of what?
Petition itself.
188 of petition.
They had made an application, lordships, and it is the state level environment impact assessment authority, CR, A7.
This is a state impact authority. They made the application.
Responding to their application.
So my application is what is extracted in.
No, that's exactly what this is the application.
This is the.
No, he's saying this in this application they had given this detail, but this is not required.
Why, lordships, in this particular place, why it was required? Because of the riverbed, lordships. The ecological area of this place, lordship, since the two states were involved, Haryana as well as UP.
Just one thing. There's what his second argument of his is, we are with you on that because he's given that, and prime facie merely because the annual limit is fixed doesn't mean the daily limit is arbitrated. That's not correct. Daily limit, he has itself mentioned, it will not be. But what his second argument is, to support his argument, what he's argued is that the EC which was given, the form which is prescribed, because he's relying upon the report now, the Central Empowered Committee. The Empowered Committee has itself said that nowhere daily limits are prescribed. And then he says the form which is prescribed, which we referred to at page number 800, 400 and odd, 400 and odd of 415. He says, in the form which is prescribed, because we notice in the form there is a requirement with regard to daily limit, daily cubic meters. He says that will not apply to him. What do you say on that?
Sorry.
At the time it had been considered, his application had been considered, this aspect had been considered in view of the mining plan that was there, Lordship. The number of trucks which will be moving every day, the movement, the laborers which would be there every day. Lordship, as per that, this was included. Deliberately, it would have been included at that point of time. Maybe the deliberations at that point of time can be placed on record, Lordships. Since it has come, Lordship.
Just we wanted to know. Please can you tell us what's the position? He said that Central Impact Committee is given a report completely in his favor.
Never have I seen since the NGT Act has come a report like this. And I'll just answer that question directly on 3 points. Sand mining all over the country, riverbed sand mining all over the country, the unit is always cubic meters per day. It is never tons per annum or metric tons per annum. There are number of ECs. That's point one. Two, my lords, your lordship said sand mining is something that is replenished during the monsoon. Therefore, the EC says that after the details you have supplied to me, out of 365 days, mining is permitted only for 225 days a year. Therefore, this daily limit is prescribed and we are...
Where is that EC? Where is
the same EC, the columns at the below, they prescribe
290?
Well, it's 290 of the appeal, Millets.
That says that it will be done on so many days.
Yes, it prescribes 225 working days.
It also says number of trucks.
Yes, but it's a detailed analysis.
Per day,
and always cubic meters. And my learned friend has mined half of annual limit prior to replenishment in the monsoons. Please see, this is from April to June. This is the river at its driest.
Number of days per hours per day, number of workers, number of trucks.
There's a calculation for 3361 per day. So now for them, SIA has accepted this application filed by the applicant and granted clearance. Now for applicant to say...
Given details not only of the quantum, it's workers per day, number of trucks.
There's a reasoning for 3361 per day. So for them to now say that, sir, this is all a mistake and only the annual will apply, by that logic, they can mine the annual limit in 1 day. There has to be a...
You're appearing for whom?
Well, I appear for the original applicant before the Green Tribunal. And the other shocking, well, this is one, the other shocking aspect of CEC's report, and therefore, Malaz, I'm requesting my laws to interfere because CEC says no consent to operate is required for riverbed sand mining.
That is a debatable issue. In some cases, there has been...
No, it's a very hyper-technical...
argued, my lord, consent
very well.
to operate and establish has been held in my favor to say that at the time when it was granted, it was the law was not there. It came 3 months later. Before that, I had got the consent to operate. Before that, I have got it. So, blood.
No, consent, but then why will you have...
Operate and establish.
1 minute, please. Then why will you take a consent if it was not so?
No, because blood, the judgment said, in one judgment, blood, it was said, within 3 months you are supposed to get it. So, when the judgment came within those 3 months, I got it. There was an order passed to them.
So, but why is this... but this CEC report is that way. But why did you not... Okay, this came on 27th of September. You not filed reply to this.
I've put my objections to the CEC report.
They have filed an objection.
Yeah. Let's see your objection.
Well, it's my objections have been filed with the IEA, Malats.
But one more thing I want to say, Milord, apropos what the learned Additional Advocate General said, that in the CEC report, what is stated, Milord, is the Department Director, Department of Mines and Geology gave them a letter which is also annexed. The District Magistrate Saharanpur gave a letter that there is no daily limit, which is also annexed with the report. Now, if all those, Milord,
1 minute, please. These are one, Mr. Kumar, these are all opinions.
No.
The decision, these are just like arguments by you or by the other side.
No, Milord.
The opinion which is given or the decision which is given is by the NGT. And even the author of the EC will not be able to give his finding. The finding will be given by the National Green Tribunal.
NGT unfortunately has not given any finding. It has only said we accept the report.
Because
that's all.
Fine. But
without
now
giving any reasons for
we are now examining it. So it's for us to decide.
Examining. I'm not joining it.
We are examining it. Yes. So we'll have to go into the question whether daily limit is prescribed or not. So that's a simple issue before us. The CEC report carries weight because they're experts in the field. Carries weight. Sorry. Carries weight because they are experts in the area. But we cannot give a, just like you argue.
No, you're not giving a carte blanche to a CEC. I am saying, Milord, that
let's see your
should be here, Milord, to respond.
We'll make Look, we can do that immediately, but we wanted to go it little, we'll spend 5-7 minutes more on the, and then if required, we may direct them. We may also require a copy of the mining plan because given by you itself.
Well, my objections have been filed with the IA dated 2507.
We've got that.
My lords, on the issue of daily limit, my lords may have page 5 of my objections. Now, here is a case, my lords, admittedly pursuant to data provided by the miner, by the leaseholder. They operated the mine for 81 days from 1st April.
That they are accepting.
And half
that we're not going to, that they are accepting. Question is whether there is any daily limit which is fixed or prescribed.
My submission is they have throughout been prescribing. Please have page 5 at the bottom, my lords. The following documents which list exact daily mineable limit have been ignored by the CEC. Now, CEC in its report relies upon documents prescribed on the administrative side by UP state officers, not by the environmental bodies. State officers, district magistrate and UP minor mineral concession rules are only concerned with collection of royalty on an annual limit. They don't, their concern is not with respect to what is good for the river, that particular riverside, whether the river is at a bend or meandering phase, how much can be mined at that particular area. That is done by the environmental authorities. SIA accepts their application. In their application, they say, this is my mining limit annual. This is my daily limit because I have these many number of trucks and laborers to at the site to move. SIA accepts it as it is and then says, all right, this is your annual limit. And this is not just in the environment clearance. Your lordship will have at page 6 at the top, but the environmental impact assessment report, which is at page 231 of the appeal, serial number 24, and the terms of reference issued right after the LOI to the appellant. All three of them mentioned throughout have been mentioned by the appellant.
The term of reference means what?
Well, as terms of reference is after the LOI is issued, a terms of reference is issued for conducting the EIA report, preparing the environment.
That also says that?
That also says this. Applicant himself.
Page number?
Well, this is page 191 of the appeal. It extracts applicant's own submissions.
That's not the EIA report. That's 191 we had referred to earlier. This is the terms of reference.
Please, Malad.
The terms of reference itself includes that. How is it, Mr. Sanjiv Kumar? How can that be accepted?
The understanding was
the terms of reference for the EIA itself includes that. And that's issued by the EIA, Environment Impacts Assessment Authority.
What does it say?
No ambiguity on this.
Para 2 at 189.
It's something seriously.
But it starts at 188.
We are just asking CSC to clarify and asking them for that.
Please.
Let the CSC clarify.
Please.
Your mining plan also, please place it on the
Sorry.
mining plan.
Mining plan.
Actual mining plan.
Fine.
The applicant will place the mining plan on the spot within a period of 10 working days. Next page. Our attention has London Senior Advocate appearing for the applicant has drawn our attention to report number 21 of 2024, dated 27th of September 2024, filed by the Central Empowered Committee under point D, relating to whether daily limit was prescribed for sand mining in the present case. So stop. CEC is held. CEC has concluded that no daily limit has been prescribed for sand mining, in this case by any authority, and therefore the applicant cannot be said to have excavated excess mine material upon the overall excess excavated mine material. Full stop. On the other hand, our attention has been drawn annexure A7, which is issued by the state level Environment Impact Assessment Authority, page 180, which under column
What is
20, comma,
Milord,
22.
Please permit me to interrupt. What is recorded at page 189 is para 2, salient features of the project as submitted by the project proponent.
Correct. We will do,
Please.
which refer to the daily production of mine stroke day, comma, number of working days. In columns 20 onwards,
20.
Production of mine stroke day, comma, method of mining, comma, number of working days, working hours per day, number of workers, number of vehicle movement stroke day. Full stop. The submission with reference to the what annual quantum it is submitted is an additional condition which will not obliterate the production limit per mine per day. Full stop. Attention is also drawn to
A12, A12, March 21.
annexure A12 dated
6 March 21.
26 March. A12 is at which page?
86 doctor, starts at 280.
Page
286.
annexure A12 dated 26 March 2021. I hope it's not the same document.
It is the same document.
It's a different document. That was
June 2020.
Okay, that is June 2020.
That's the same thing. What's the terms of reference? This is
The table is the same, Milord.
Maybe the table.
Proposal.
That's terms of reference. That you first say the annexure A7 terms of reference dated 20th June 2020. Cut off the later portion with regard to the annual. Reference is also drawn to annexure A12 dated 26 March 2021, which is the approval,
EC clearance.
which is the EC,
Environment clearance.
which is the environment clearance, wherein paragraphs 20 to 26, 20 to 25
Milord,
have been
it's column 20 to 25, not
columns, sorry, columns 20 to 25, which make reference to production of the mine per day, method of mining, number of working days, working hours day, number of workers, number of vehicles, movement per day is mentioned. Stop. Column 17 of the said column prescribes the total proposed production in the LOI, which figure is given in which figure relates to product total quantum of extraction per year. Stop. The contention raised by the respondent is that the quantum of production per year operates independently, and quantum of production of mine per day have its own significance, given the fact that the riverbed sand mining is being undertaken. Full stop. The quantum of production per annum does not obliterate the need to maintain the prescribed limit of extraction per day. Full stop. Attention is also drawn to what is the third document?
Well, his third document is the EIA report.
No, Before that, Lordships, may see page 293 also for a moment. In the same EC, the environmental clearance, the condition number 5, Lordships, about the mining plan.
Okay.
Clause 5.
That I'll mention in the EIA, the next page. The EIA report specifically, the environment clearance also specifically states that the mining will be done as per the approved mining plan. And in case there's any violation of the mining plan, the environment clearance shall stand cancelled. Next page, which is the third
document is the EIA report, page 2, annexure A10 minutes.
A10.
Let's EIA report, page 231 at 247.
Page 231
at 247 minutes.
Not seen.
Column 24 minutes.
Lastly, our attention is also drawn to the EIA report, which was submitted by the appellant, which again specifies the total proposed production in the LOI, production per mine/day, number of working days, number of working hours, number of workers, number of vehicle movement per day, page 247. Don't say lastly, now say lastly. Our attention is drawn to which is that form?
It's page 417.
415. In the CEC report.
Yeah. The CEC says.
The attention is drawn to form 2, page number
415.
It's an annexure to the letter at 413, Milord. Application for seeking prior environment clearance.
Attention is drawn to form number 2. Annexure, which is an annexure to the
22
to the report, the CEC report number 21 of 2024. To stop the said form in column number 8 dash details of project configuration, project within brackets, multiple entries allowed, brackets closed. In column C, in subcolumn C, it requires the project proponent to give details of cubic meters, give details of quantity produced in cubic meters per day. So stop. We have referred to the said column, said form number 2, in view of the observations in the report of the central CEC that form number 2, that the form prescribed for grant of EC in the extent case has no columns wherein daily limit is to be entered by such applicants. Stop.
One more thing, if I may. My actual form as submitted is at page 277, annexure A11. In my SLP, in my appeal rather, volume 2. 277, annexure A11 in volume 2 of my appeal paper book. This is the form I filled up with. In this, my lord, your lordship will find 278 column 8, details of the project configuration.
Yes.
If your lordship will kindly see number 8 in the middle, project configuration, plant equipment, etc. Below that 8.2 products, sand, bajri, boulder, quantity 7,56,000. Then unit others, other unit cubic meters, mode of transport, road, etc. This is what I actually filled.
This also, Lordship, there is a reference on page, Lordships may have 270A, column 6, Lordship. Details of the terms of reference and at 30th June 2020, terms of reference is specified there.
Okay. That's all right.
Just one. We'll add,
Please, very obliged.
the Central Empowered Committee will file an affidavit meeting the said assertions made by the respondents. Next paragraph. We may, however, note that the appellant has relied upon form number 2, which has been placed on record as a form number 2 submitted by them, which has been enclosed as annexure 11. And in the said column, with reference to column number 8, in the said column, no details have been given. Stop. However, the stand of the respondent is that the said form specifically makes mention to the
Terms of reference.
terms of reference, which includes the total quantum of production per day, but total permitted quantum of production / mining per day. So stop. Let the said the CEC will file their affidavit within a period of 3 weeks from the date copy of this order is received by them.
Respondent number 4 is Ministry of Environment and Forest.
The Ministry of Environment.
The best person to.
Okay, Ministry of Environment and Forest will also file their affidavit.
Respondent number 4, Milord, if you're not checking.
Within 3 weeks from the date copy of order is received, served on the central agency. Full stop. Response may be filed by either side to the said affidavits within a period of 2 weeks after service of the affidavit by the CEC / Ministry of Environment and Forest. Pre-list in the week commencing.
Which mining is going on, so may I request?
Pardon?
The mining is going on.
No, but restricted to the per quantum per day. Place you restricted to per quantum per day.
It's already restricted, Milord, the way, Milord, the annual.
1 minute, not annual. Place restricted to the quantum per day.
But my friend is today.
At prima facie, you'll have to comply with the order. Look, prima facie, you'll have to comply with the NGT order.
The clause itself is omitted completely in the environment clearance.
They've amended it.
They have amended it, Milord. I have annexed it.
You'll have to comply with the NGT order.
So, Milord, if the environment clearance has been.
1 minute, 1 minute.
Not the subject matter of challenge.
1 minute, please. You have been, in your case, you'll be governed by the old EC.
No, that very EC. Milord.
1 minute, please. That now that EC clause has been omitted.
Yes.
Well, it's Annexure 22 CEC report. So it specifically says cubic meter per day as to be prescribed.
No. Have you obtained a fresh EC?
Milord, if a lordship just.
1 minute, Mr. Ajit Kumar. Have you obtained a fresh EC?
No, Milord, it's not a fresh EC.
Now, 1 minute, Mr. Ajit Kumar. The National Green Tribunal has interpreted that EC. Which they have the right to do as per their interpretation. 1 minute, Mr. 1 minute, please, Mr. Ajit Kumar. Good or bad, the NGT has interpreted that EC. They have reached the conclusion that it requires you to maintain per daily limit also. As long as that portion of the order is not stayed, you'll have to comply.
Milord, may I just make one submission? The NGT does not say that I have to maintain a daily limit.
That's why they impose. That's why they impose penalty. Why are you saying that? How can you argue that?
No.
They've imposed penalty on that account.
They have asked me to deposit the money which I have.
Correct. That's on account of the violation of that clause.
Yes.
So please maintain that limit. Please. In the meanwhile, the appellate.
Right, Milord, that kindly indicate on my part, this part, that this clause regarding daily.
We will say so, but we will not agree with you on that.
For the moment, your lordship will not agree at this moment.
For the time being, the appellant will ensure that they will not extract sand above daily limit of
3360 cubic meters.
3360 cubic meters per day.
Lordship only indicate I have mentioned that this has been omitted.
So we have passed the said direction. We have passed the said interim order in spite of So I didn't want to record it because it will look we have rejected it. But if you want, I can record it.
I am saying, my lord,
It will not be in your interest to have it
I
recorded.
will leave it at that.
If you want it, I can record it. Because then I'll have to say, in spite of your contention, I'm not agreeing with you at this stage.
But that would be an interim part only.
That's fine. If you want, I can do it. I've got no. It's for you to decide on that.
I have not, your lordships have indicated when it will be listed.
Relist in the week commencing. When will about 6 weeks we'll have to give?
January, your lordship.
No, it's January will be too early. 17th of February. Week commencing 17th of February.
Grateful.
Grateful.
5.
Obliged.
Very straight.
This is my SLP.
Mr. Ranjit Kumar, I'm adding one sentence in your favor. Not in the last column, not in the last paragraph, but above that. It is also how it is pleaded on behalf of the appellant that the requirement for per day production has been deleted in case of side matter.
Lordship may say omitted.
Omitted in case of side matter.
Lordship, much obliged.
Is there any quarterly limit now fixed?
Sorry, my lord.
Is there any quarterly limit fixed?
Only annual.
Now there is no.
Of the clause which provides daily limit. So now we have to stick to the annual limit.
There is no other limit.
So that's for 225 days. That
No, then there must be something in it. Then the quantum of penalty is pretty too high. Even if we disagree with him, then the quantum of penalty is little too high. Because if they've done away with it, then then it shows that probably it was not, quantum penalty may be too high. Look, please, we are not experts. Let me put it very clearly, we are not experts. We have to interpret the law and apply the law. Yes, item 5. Sir, the principal is here.
I have those copies of the Pollution Control Board consent, if I can tender.
एक सेकंड ओके ये सब एक ही सभी एक मिनट देखना
These are 2023. Your application is of 2020. One application is 22. What about the earlier?
What the 2023 and 2024 consent, bullets?
Not before that.
No, we have a 2021 consent also.
You have that?
That also I have, but I don't have a 2022 consent. Right? And now I've got a 2025 consent, bullets, till 2025.
For less than 5,000?
Yes. And bullets, let me tell your lordship another thing. And may I tell your lordships another thing? This argument that he is an ex-director of the company, brothers, who is fighting this.
That normally happens. That normally happens.
Which is fine. Now, brothers, he talked about the slush and all that. In fact, we have cleared all that, and we are within ambient standards throughout.
Okay,
even this year I am within ambient standards.
Banker interview in cash.
I'm sorry?
Let banker interview in cash.
Yes.
Right now.
Can they be encashed?
Okay.
Malad, may I request Malad? I just had a discussion with the council for the pollution board. He's just getting instructions. Malad, if this consent has to see, Malad, then keeping in mind that content is earlier also there's a violation despite because
therefore, look, please, there are two things. For the earlier violations, he'll have to pay. There's no doubt about it.
Yes, ma'am.
If he has the right consent today to operate, we will not stop that either. That will not be correct. For the earlier violation, we'll take him to task That's something.
Small point,
But we are not going to, because it will have its, it will have its cascading effect on several things. There'll be third persons, the workers working there. There'll be sugarcane farmers will be affected. Balance of convenience has to be kept in mind.
And that's it, my lord. Just one request, my lord. Despite of number of direction of.
We have understood that. We are directing encashment of substantial portion of the bank guarantee.
As if today also my
To teach them a lesson because they cannot be part.
They mentioned that 5,800,
I
but
appreciate what my lord is saying.
actually
That's not
they are
done.
pushing more
That's
than
not-
7,000.
That's not
We
done.
agree. We agree.
Right. What agree, you have to accept it.
Yes. No, agree means I'm not going to argue on any of this, brothers. That's what I meant.
Right. The matter was passed over to enable the applicant to place on record copy of, to obtain instructions on whether the applicant had consent to operate during the relevant periods up to 2024. So it is stated at the bar, the consent to operate was obtained except for
21, 22.
except for 2021, 2022.
No. 2021 we have, 21, 22 we don't.
2022, except for the year
21, 22.
2021-2022.
No, 21, 22.
Only for the year 2022.
For the year, is calendar year therefore, 2022. Full stop. Next paragraph. We have also been, our attention has also been drawn to the rejoinder affidavit, wherein the applicant has accepted that the annual production,
Not in per day.
and the daily production was in excess of 5,000.
Was it an average of 5,800?
The average daily production was in excess of
800.
5,000 metric tons.
Yes.
Metric tons. Full stop. In these circumstances, we direct encashment of bank guarantee of to the extent of rupees 6 crores as an interim measure on account of violation of orders of this court, including order dated for causing
September.
3/1/2023 and causing environmental damage. Full stop. The said encashment will be done. In whose favor is the bank guarantee?
Pollution control.
Pollution control board.
The pollution control board.
Pollution control board's favor.
The pollution control board, Maharashtra Pollution Control Board will act accordingly and file an affidavit of compliance within a period of 3 weeks from today.
3 weeks. Okay.
In the meanwhile, we permit the applicant to start production we permit the applicant to crush sugarcane and produce sugar, subject to maintaining daily limit of 5,000 tons per 5,000 tons per day. To stop. The applicant will file affidavit of its managing director that they will affidavit come undertaking of the managing director that they will adhere to the said prescribed limit, and in case there is any violation, he would be responsible and liable to the court in his personal capacity.
May I request, my lord, may direct some committee to observe daily.
1 minute, please. That's good enough. Let him do it. There's an excise officer sitting over there.
There's only one request, Mullah. My environment clearance beyond that is not being proceeded with.
That's, you have to move there.
No, I believe it's coming before your lordships.
No, it's coming before.
Oh, I see.
So that's what I was told.
No, Mullah, it's coming.
What is before Justice Gawai?
Initially, Shakti petition was entertained by Honorable Justice Gawai's bench, but subsequently, in October.
I'll see that. We'll see that.
Yes.
Yes. Right. That is pending. They want to give it to us.
Move an application and the
That we have done. That also we need not read. That direction we have given you liberty in terms of.
Yes, but brother, they are not proceeding because of that.
Move an application, we see.
We have done that.
My lord, just
They have just concerned, my lord, of distillery only, not for the sugar industry.
They have not for the.
No, my lord, they applied it. It is under consideration, my lord.
You have applied for distillery, not for sugar.
No.
Is for
distillery they have.
Anyway, let's examine it. The actual production of sugar per day, including the quantum of sugarcane which is crushed, will be submitted by the applicant along with the affidavit, which will be filed periodically after every month.
Deeply obliged.
Which will be filed periodically within 10 days of each calendar month.
Fair enough. And the permission is for sugar crushing capacity, not distillery. It's there. Deeply obliged.
We list in the week commencing March 2024.
It may be open for us to move an application.
In case there is violation of this order, the respondent may file an application before this court. The other matters after this. What is the next case about? Flat number. Okay, sir. That we take up at 2 o'clock.
Lordships are taking up lordships listed.
Yes, pick up
at 2 o'clock.
Whether why were you hesitant?
No, because they specially fixed matters may not.
No. This is especially fixed. I apologize for the delay.
With my lord's kind leave minutes.
Yes, please.
The Bombay High Court passed an order yesterday evening directing demolition in a contempt case. An order has not been uploaded, and they have started demolition in the morning itself. My lords, may kindly have a look at the minutes.
So we can't, you have to file a petition at least. Like we listed tomorrow morning, what is the position?
Minutes, we have already filed minutes, but there is no impugned order
doesn't make a difference to file the
it only happened yesterday. It has to be stopped, otherwise nothing remains by.
No, we can't do it without that. It will be listed tomorrow morning. Or if you want, we can list it today in the afternoon itself before a break. Have you filed the petition?
Today itself.
Okay.
We have filed it. Great.
What is the matter about this? Unauthorized construction?
They say, Millets.
It's unauthorized construction.
Yes. One floor, not the whole, one building. Above the floor is unauthorized, the rest is authorized.
Send it to Justice within last week.
Great. Wait, give me
that.
Yes, have you taken instruction?
Instruction, my lord. So far as the payment of maintenance in the tune of rupees 10,000, my lord, my client has retired, my lord, in 2016. But it is bit harsh. It will be a bit harsh. And
no,
so
but
far
then,
as the residence
look,
is,
you're getting the property in terms of that. The children must be working.
no, my lord, he is retired. 2016, he retired, my lord. And so far as the residence was the issue before all courts. So far as maintenance, there was no claim or.
Yeah, we are saying, look, we have to find some solution to the.
But a lump sum amount, my lord, he is ready to pay a lump sum amount. My
how much amount? Lump sum amount?
But he has quoted 5 lakhs, my lord.
5 lakhs.
5 lakhs.
That will mean about 50.
My lord, I got also instruction on that. If I could not stay there, as my lord is not going to merit of the matter, in that case, my lord, they let them put some amount in fixed deposit so that I can monthly get 20,000 odd amount so that I can maintain
20,000. No, then in that case, we can ask them if they give you, say, 10 lakh of rupees or something like that. Because in the senior citizen scheme, the rate of interest in the post office scheme is about 8.7% or something like that.
But I have to take property on rent. I have to maintain myself.
So, what is the rent you're paying? What rent were you agreeable to pay?
If my lords decide,
okay, if you can give about 15 lakhs or 20,
15 lakhs will be
you don't have to take any property in hire also.
Yes. That I can understand. But 10 lakhs.
15 lakhs, if you pay her, lump sum, if you pay her 15 lakhs, she'll vacate the property. She'll fend for herself.
Bargaining, let it be 10.
No, I'm not going to bargain. There's no question of bargain. Look, 10 lakhs, I realize, even if it's 8% interest, all that she'll get in a month, in a year is about 80,000, 85,000.
Yes.
It may not be less. It will be too less.
She was working in a concern of the West Bengal government, man.
He's getting pension?
No. I'm not getting
lump sum.
That has come on record.
Retirement, man.
Okay, you pay 15 lakhs, just take instructions. We keep it next week. Pay 15 lakhs, we'll finish it off. 15 lakhs, you may have to arrange for it, but you're getting your property also. The value will be more.
That I understand, man.
Maybe your children will have to put in a little help to help you. Just ask them. I think it can be worked out. That the gap is not so much.
May I quote,
look, 5 lakhs you are giving and getting a property and rent. Correct? 5 lakhs of property and rent would have cost you.
Lump sum, my suggestion was, my client's submission is 5 lakhs as a whole, without any search operation. Because 2023 September, we searched out this place. Where,
no, but you're not paying 5 lakhs in addition to that property. You are giving addition to that property at that time. Correct? Why are you not giving 5 lakhs in addition to that property, rent of the property? Therefore, please no, make it 15. Just talk to him. Just talk to your client. Should we pass it over? Or you...
Let it be passed over. But let it be
keep it on next week. I will also take.
Okay, next week.
Next week.
Next week.
But next week on Thursday itself.
Thursday. That's the thumb rule. Don't ask us to change that.
But top of the list,
It will be number 1 or number 2.
Great.
My lord, in item 10, I am led by Mr. Banerjee, London ASG, in this matter. He was just here. May kindly pass over.
When you start, you let it come, you start, what is it about?
My lord, I had directed us to grant an opportunity to the respondent to inspect the original record in this case. We had sent an email to them inviting them to inspect the original record, but they didn't appear.
So what is the impugned judgment? What is it? So look at the complaint itself.
Yes.
Was
Complaint, my lord, is that?
My lord, may I
page
kindly
20,
pass over, Mr.
28,
Bank will
my
be
lord.
here.
you got the original records with you?
Yes, ma'am.
Please show us.
And my lord, my reply is also there, my lord.
See that. Let's first have a look at the record.
Very well, very well, my lord.
Why is it so bulky? It's the entire service file. Is service file. Take out the relevant pages in market. You could read what is service file. Criminal trial?
No, my lord.
Pending for arguments, my lord, as per the status.
Pending for arguments on what?
No, my lord. But trial has not yet commenced, my lord.
Okay. Arguments on charge?
Yes.
Arguments
Trial has
on
not
charge.
yet commenced, my lord. And the prosecutrix, my lord, apart from prosecutrix, parents has also given their statement in the criminal case, my lord. In the criminal case, before during the investigation also, and before the magistrate also, they have given the statement. Charge has not been framed. This is my instruction, my lord.
The next date is 17 January 2025.
Okay, that's fine.
My lord. Reason is at para 13 of the impugned order, my lord, where they have said that why.
With these.
Very good.
Conducted a preliminary inquiry initially.
Yes, my lord. It's already recorded in the order itself, my lord, page 38 of the SLP paper book. It's already there. There was a preliminary inquiry, my lord, and there was a report by the intelligence unit of CISF, my lord, where they have expressed the concern that there was an atmosphere of unrest among the member. And that was the reason, my lord, is squarely covered by Tulsiram Patel, my lord. My lord, may kindly see page 38.
Page
38 is the order dispensing with the inquiry, my lord. 4th April 2018.
There are two markings over here. 38.
Page 38.
Okay, after appeal, there's SLT.
paperwork. So 38 is start, para 2 is relevant, my lord. Page 39. There was not only a preliminary inquiry, my lord, but rather a report by intelligence unit of CISF. Report was dated 1st April 2018.
Is it there in this file?
No, it's not on in the SLP web.
Then where's the report of the vigilance unit? Is there?
Yes. Report. First April के जो reports.
This is 3rd March. Just tell us, after you got when was the FIR registered?
It's 29th March 2018, my lord.
29th March
2018.
Then after that, what happened?
Then concerned police officer, police station, my lord, inform us about the arrest, that we have arrested this person as per the rules.
It was not done within the CFS campus. That was within the CFS campus or somewhere outside?
My lord,
No, this is the FIR. I'm talking about the intelligence report of 1st of April.
1st April 2018.
So 29th it happened.
Yes, my lord.
And the FIR was launched on 29th itself?
My lord, the incident is prior to
20th,
that, my lord.
Incident is of 20th of March.
Is of 20th of March. FIR.
9 days.
20th of March 2018.
Yes, my lord.
After 9 days, my lord.
That is for police to.
On 29th, the FIR is registered?
My lord, FIR is on 29th of March. And same day, arrest was intimated to the CISF. Then, my lord, on the same day, we instructed for a preliminary inquiry, and also, my lord, we requested the intelligence unit to submit the report on this.
Okay.
My lord, based on the preliminary inquiry and the report of intelligence unit, we dispense with the inquiry. My lord knows that Article 311 gives finality to such decision, my lord. It's
where? Which page is the FIR?
FIR is, my lord,
Page 38, my lord.
38.
Page 38, my lord.
38 is the...
My lord, 28 is the FIR.
28.
It's a 4-year-old. Both these documents, preliminary report as well as the intelligence report, High Court take note of, my lord, in para 3. But there's no discussion on that.
There are two reasons which are coming out quite apparent here.
Sorry, my lord.
There are two reasons which are quite apparent. One was there's a lot of anger in the unit itself. After all, the girl was just less than 5 years old. She couldn't even explain what has happened. When she had that problem, medical problem,
Yes, my lord.
they went to the hospital twice. It's on the second occasion when the problem didn't stop that they referred her to the gynecologist,
Yes.
who then said that this has probably happened and please talk to her with love and care because she's been through a trauma.
Correct, my lord.
Now, the very fact that she had to be spoken to with love and care, subjecting that child to cross-examination or anything would be impossible.
Yes.
You can understand the trauma which a child will
Correct,
go
my lord. And
who doesn't even understand what has happened.
no, my lord, I fully appreciate, my lord. But
One minute, please.
yes, my lord.
The second issue is that there was a lot of resentment and anger in the unit itself, and continuing to retain you in the unit, and they were suspecting that there would be difficult. Aren't these two reasons good enough?
No, my lord. Therefore, my lord, in response to your lordship's query, my lord.
And the reasons have to be determined by not by you or us.
No.
Is to be determined by the authorities.
Correct, my lord. But before that, my lord, what has been concealed from this honorable court is, and I'm addressing your lordships on that aspect, my lord, but please have my counter affidavit for a minute, my lord. Your lordship has seen, my lord, but before that, my lord, if your lordship will see the FIR, which is at page, just a minute, page 28 of the paper book, my lord, was.
Yes.
Now, my lord, may kindly see the FIR. Just a minute.
Look, there are two things. Let's be put it very clearly to you.
Yes.
Don't put them into two different compartments.
Yes, my lord.
One is the merits. Second question is of dispensing with inquiry.
I'm only confined to that.
So please, when you argue, do it separately.
Yes, my lord. And therefore, my lord, what my submission would be, my lord, that the FIR was registered on the basis of the statement made by the doctor, my lord. This and the informant is the father. Please have page 32, my lord, for a minute. 32 of the FIR. What is the basis of the FIR, my lord? It says, my lord, that on 28th, my wife told me that my daughter was urinating and underwear, and she was irritated. So I and my wife and with our daughter went to JNPT hospital, where Dr. Kelkar examined her and advised her to go to gynecologist Dr. Manjusha. Please mark this word, Dr. Manjusha. After examination of my daughter, Dr. Manjusha told us that the veil of my daughter was torn. And also the doctor told to Dr. Kelkar and gave us medicine and told us to talk to so and so. And therefore, my lord, the FIR in this background, my lord, FIR was registered. Now, my lord, may please have the statement of Dr. Manjusha and the medical report also, my lord, for a minute, which was not placed before your lordship when your lordship issued notice, my lord. Now, my lord, medical report starts from page 38 of my reply. And relevant is, my lord, page 38.
Yes.
Now, my lord, page 38, my lord, at the top, your lordship will see that there is a noting that no injury mark. Next.
There's no injury mark, that's fine.
No, my lord, next also, my lord, next page also, my lord, for a minute, my lord, page 39.
Yes.
No hymen injury.
Wait, no. There's no injury because 9 days had lapsed, but the thing was torn. The veil was torn. That's also stated very clearly.
No, Lord, that was the statement of the father on the basis of.
No,
No, my lord, informant
Doctor has said that.
No.
Look,
Now, my lord,
But let's,
no, please allow me, my lord. Please have the statement of the doctor for a minute, my lord. Please have the statement of the doctor, which is at page 57, Dr. Manjusha.
57.
Yes. And this was not placed on record, my lord. That is the
No, your page numbers are not tallying.
yes. Page 57, my lord.
Your page numbers are not.
No, my reply, my lord.
In your counter,
yes,
page 57 is the middle of.
Page starts from page 48, my lord. Starts from page 48. Relevant is page 47, 57, my lord.
The page numbers are not tallying, Council.
Yes, my lord. In my
Your index, you mentioned page 20 to 108.
Lordship, got it,
entire annexures.
It is like this, my lord. Page 57. I, Dr. Manjusha.
This is page 57.
My lord, can I? You have a paper. Lordship will.
And we can't look at the index because we've clubbed everything. And
Lordship,
page 20 to 118.
I apologize, my lord, for the inconvenience, my lord. But
35.
Should got it. May I read, my lord? I, Dr. Manjusha. Yes. It is.
You take a little trouble with the index when you file it, instead of clubbing everything and saying copy of entire annexures.
My mistake.
Which were part of the writ petition. Page 20 to 118.
And please come to page 52.
52 minutes.
Page number is not telling you.
52.
You don't know which page that would be.
This is the summoning. This is the summoning letter, my lord, from the IO, and then
this is from the hospital.
Yes, this is the summoning.
This is
history
the hospital
of sexual assault.
And
this is the MLC.
And then yes, my lord. And then my lord, may kindly see the
If you turn to one page before,
page, my lord, page number, my lord.
one page before, it confirms two things.
Yes.
That the first time they went over there was on 20th.
Yes.
The second time they went over there was on 28th.
Yes. Yes, ma'am.
That was on 28th.
Yes.
And then on that day itself, it is recorded history of sexual assault.
No. Your lordship got this.
And then there is examination done with regard to, because then the FIR is registered, forensic medical examination,
yes.
History of sexual assault, which is on which date? 28th.
Incident is of 20th, my lord.
Correct, we are aware of that. We are aware of that. 20th also they had gone to the hospital.
For urinary infection, my lord.
1 minute, please. At that time, the girl did not say anything.
Yes.
The 5-year-old girl or less than 5-year-old girl did not say anything. But the mother noticed bleeding. So she took her over there. And there was a whitish discharge. They took her to the hospital. The doctor felt probably it's a urinary tract infection. Because they didn't take her to the gynecologist or anybody.
Yes.
28th, when there was again an issue, then they took her. At that time, then the doctor refers to a gynecologist, and the gynecologist then noticed that this is a case of sexual assault, and it's recorded.
No, my lord, please allow me.
Now refer to page number 54.
54, my lord.
Yes.
54 is Dr. Prashant Shashikant. He is not the gynecologist, my lord.
No, page 54 of the written report.
Yes, page 54, my lord, 2nd April 2018.
No, I'm on the.
Page 54.
It's already established your page number is not tallying with ours.
Is referring to SLP paper book.
No, your counter affidavit.
My counter affidavit.
Navi Mumbai Municipal Corporation General Hospital. We are looking at the forensic medical examination report.
Yes, my lord. That starts from page 38, my lord.
That is that
page 34. It starts from page 34.
Forget about page when it starts. Come to page 54.
Yes, yes, my lord. Page 34. I am reading, my lord. First, initially, she came on 20th of March. Then,
we have already noticed that. Come to page 54.
Yes, and then, my lord, finally, when the doctor was summoned, please try to appreciate, my lord, when the doctor.
I'm aware of that fact. It corroborates with the FIR. No. These facts are corroborating and tallying with the FIR. Come to page 54, please.
54, my lord, I'm coming.
This page number is not 54.
54, I'm reading. May I read, my lord?
This page, please. Give it to him.
54 is, there must be some. No injury mark. So this is mine is, okay, very well. I've seen that. Page 55, I'm referring back.
Page 54, please, not
50,
55.
54,
I'm going
yes.
to form 55 to 54.
I'm reading page 54 also.
Yes, please read.
Victim is 40, this is the complaint. Victim is 44 years old. Her father gives a
This is
history of.
written by the doctor.
When
1 minute, please. Let's not quibble over this thing. Whatever is the fact,
when
is
the
the
patient,
fact. You can't get over the facts. You have to meet the facts.
Stated by the
As
victim.
stated by the complainant.
Records that this is stated by the victim.
Yes, yes, Lord.
Not by the parents, by the victim herself.
And when she was examined, at
Inquiry
page
is confined to dispensing with that particular inquiry, my lord.
He wants to go on the merits, let him go on the merits. If he has a strong case on it, why not allow him?
Yes, and Lord, when the inquiry took place, when she was examined, nothing.
Please read that portion. Why are you shying away from that?
Victim is 4 years old. Her father gives a history of victim going to neighbors. On 17th of March 2018 to 20th of March 2018, she complained of some itching over urinary area and little discharge. So her parents took her to gynecologist, where she was examined and said that there is a rupture. Hymen and when leading Q, to which she gives a figuring by their name. The statement of the doctor who has already given a report.
In that document, find which page that is so that we can at least look at it here.
My lords, the report names him, my lords. I've seen that.
No, look, there is.
You cannot find it at all.
There is some.
You don't seem to have found.
No, but there is some problem in paging, my lord. So please allow me.
Find it at least.
It is not there. I can see, my lord, that page is not there. I apologize.
You not find it at all.
That page is not there. It is not tallying, my lord. So therefore, my lord.
Not tallying. This is the copy that you have given us. So find it in this copy. If it is there, it is there.
Yes.
Whichever page. Then we can look at the same page in this copy.
Yes, it's not there. It's not. I'm sorry, it is not there.
Not there.
Not there. But that document is.
Whatever it is, whatever you have filed, please we can go through.
No,
on the merits, therefore, this is corroborated. The FIR is corroborated by the medical evidence of record.
That is one aspect, my lord. Now, my lord, if your lordship will see the impugned order at page 1, my lord, para 13. Para 13, my lord. So, threefold reason has been given, my lord. Page 10, para 13. The conducting of disciplinary inquiry may hurt the sentiments and fellow emotions of local residents and fellow members of the force. This is one of the reasons, my lord. To this, my lord, my submission would be, my lord. There are day in, day out, my lord. This kind of, I'm not saying that this kind of offense happens, my lord. And then,
please,
my lord,
please.
No, but
please be careful.
But difficulty would be, my lord, that emotional things will always be there, my lord. Whenever there is an offense, any type of offense, my lord, there will be people may have some grievance, or people may be in some reactions or something that would be there, my lord. So, my lord, my submission would be that only because of the fact that there are sentiments against the accused, that could not be the sole reason for dispensing with the inquiry, my lord. Now, my lord, secondly, my lord, that producing victim as a prosecutor witness in disciplinary inquiry is not feasible. The victim cannot be further subjected to trauma or cross-examination. I quite appreciate, my lord, if the victim has gone before the investigation, my lord, she has made a statement, she has appeared before the doctor, and certainly, my lord, she will make a statement before the trial also, my lord. So in that circumstances, my lord, this reason doesn't suffice to dispense with the inquiry. Now, my lord, we see the last reason, my lord. The petitioner is already under arrest and will be either in police custody or judicial custody for a long period. So, no, my lord, this reason is also not sustainable, my lord, because he has already been released on bail immediately after some time, my lord, on merits, my lord. So these only three reasons has been recorded for dispensing with the inquiry. Therefore, my lord, my submission would be that unless and until somebody is given a hearing before he is terminated, that too, my lord, with the mandate of 311, my lord. So, my lord, therefore, my lord, High Court has now, my lord, may kindly see para 4 also, my lord, how the High Court has dealt with all these three reasons, my lord. We must state that dismissal from service is the harshest punishment, and it is akin to economic death penalty for an employee. Therefore, more objective approach was required to be adopted by the disciplinary authority while dispensing with the inquiry. However, it appears from the order impugned that respondent number 4 disciplinary authority has got swayed away by the fact that petitioner is involved in a heinous crime, and conducting a disciplinary inquiry may hurt the sentiments and emotions of local residents and fellow members of the force. None of the circumstances which the disciplinary authority has taken into
We have understood that.
Right.
That's all or anything else?
That's all, no? And apart from that, my lord, one judgment of Delhi High Court, my lord, which was approved, my lord, against that order, SLP was filed also. That was approved. Lord. The judgment also says, my lord, that even if the offense is grave, even if the offense is heinous,
we are not going by that alone.
Yes.
We said there are two different things.
Yes.
One is the merits of the allegation, the second is the dispensing of the inquiry.
Yes.
These are two separate things.
Correct.
So we not gone into all that. Right up, be granted. In our opinion, the High Court was the judgment of the High Court interfering and setting aside the order of dismissal passed in terms of Rule 39, in brackets Roman 2 of the Central Industrial Service Force, Security Force, Rules 2009.
2001. 2001.
2009. Is unsustainable and contrary to law. So stop. The impugned judgment rightly notices the law as laid down by this court in Union of India versus Tulsiram Patel, 1985 3 SC, C. 398. It examines pari-material provisions of clause B to Article 311 within brackets 2. Full stop. Next page. In the facts of the present case, the victim is a child aged about 4 years and 9 months, and a daughter of a constable working in CISF. Full stop. She was residing with her family in the same locality, in the same locality where the respondent, Udaynath Turkey, was also residing. Full stop. The FIR, next page, the FIR, which was recorded on the first information report, which was recorded on 29th of March 2018, is a detailed one and sets out the occurrence in which the victim had suffered sexual assault when she had gone to visit the residence occupied by Udaynath Turkey after Udaynath Turkey, and to meet his daughter Anushka, meet his daughter, who was also about the same age. Full stop. The assertions made in the FIR are proven from the medical record, which has been placed on record by the respondent, Udaynath Turkey, along with his counter affidavit. Full stop. On the question of dispensation of inquiry, we would like to refer to two specific reasons. Firstly, the first reason is that the victim, aged about 5 years, who it is apparent did not even understand what had happened, would be subjected to examination at the behest of the respondent, and this would be subjecting her to trauma, which in the present case, which should not be undertaken, which should not be permitted and allowed. To stop. The second reason recorded was that the local residents were emotional and there was fear of violence in view of the fact that the victim was a daughter of a constable of the same paramilitary force of which the respondent, Udaynath Turkey, was also a member. Full stop. This would have led to problem. It was therefore thought appropriate to dispense with the regular inquiry. Full stop. In our opinion, the parameters as set out in Procedural Delay are satisfied in the present case, and therefore the authorities, the disciplinary authority was right in dispensing with the departmental inquiry. Full stop. Next one. The impugn judgment is set aside. Appeal is allowed in the aforesaid terms. Writ petition filed. Writ petition number.
Obligement.
6859 of 2019, filed by Uday and Turkey, will be treated as dismissed.
No, Lord, one small request, Lord. Lord, any observation? Yes, Lord.
Right. We have clarified that the observations made in this order will not in any way influence the criminal prosecution, which is stated to be pending. And the same would be decided on the basis of facts and materials. Basis of evidence, facts and material brought and recorded in the said case.
Grateful.
Obligement. The trial is pending.
We are aware of that.
Obliged.
This is a clear case which falls under the exceptions, where departmental inquiry could be dispensed with. Yes.
Unless the report from the CPCB has come, unless.
Not come. Do not come.
So we have received it.
You have received it?
From.
No status report has been received so far. This is dated 4th
Well,
November.
We have not served with the report. However, we have received a show cause notice from JKPCB. On 13th of November itself, we received the
The
notice.
show cause notice.
Yes, there are some observations that we have received on 13th of November.
Plus, I'll say that.
This is at Jammu Hospital.
Yes.
It was, there was an earlier report submitted to us.
That was by the pollution control.
There was,
We had asked the Central Pollution Control Board.
Yes, yes. That's on the record, my lord.
No, that we know. We were little apprehensive. We had doubts on the State Commission report. But therefore, we had asked the Central Pollution Control Board to conduct inspect and conduct the investigation.
Correct. Yes.
So what has happened thereafter?
Yes, they have filed the report.
You have received a status report.
I spoke to the counsel for the CPC. He said,
where is he?
Nomeless.
He's not coming.
I have to say something else. What he told me, he said that since they are not in the they are not the parties in the petition, so whenever they are directed by the court to file these reports, malas, they report it with the registrar. For they have report.
They have the registrar of which court? This court.
This court.
So why have they not placed it on record?
That's what I was saying. It should have been placed on record.
ये registrar के पास report है इसकी तो लिखने हैं.
Lord, item 12, senior on selection code 15.
You start, we'll see. Just start. We'll accommodate him.
Lord, I have not.
Well, please start.
Lord, I have not gone
Drop. To find out whether you are ready to purchase this share.
No, your lordship. This old man for 30 years was fighting and he's not in a position either to purchase nor he's willing, your lordship, after 30 years. And all three courts found that it is his property. Concurrent findings. Even the trial court dismissed on a different reason, but found that it is my property. My brother had trespassed into it when I was in Rajasthan.
Patent? What do? You build on somebody else's land and you say.
Both of them are siblings.
No, which was your land?
Both of them are old.
No, what do you do with old people? You can't. That doesn't mean that you constructed somebody else's house.
Brother,
land and you say, my house now.
Own brother, my lord. Own brother, both of them are old. Now the building will be sliced into two, my lord, substantial building. Last date of hearing, respected senior made a appealing submission that palatial building is going to be demolished. I myself was very impressed, but later on I realized that it is not a palatial building, it is a 60-year-old building which is, anyway, they are not occupying it.
No.
They are not staying in it.
But see the photographs. Kindly see the application.
This is the building.
No, that is
receiving additional documents. Photographs are produced.
8, 9, 10.
There was a substantial building.
This is not the building.
They are not occupying.
Page 11 is not the building. They are also not occupying it.
No, they are not occupying. They have abandoned it.
No. Who said this? Very much not. Look, kindly see the
My
photographs.
client is staying in the near plot here, but he knows they are not occupying. The finding is the building belongs to me, the land belongs to him, and the building will be sliced into two.
No, there is no finding that the
building.
building was nowhere in the picture.
Number 13, it's quite clear nobody's been living there because the way bushes have grown.
Yes.
Then it would have been like a.
No,
Your Lordship also see page 8, page 9 of
the bushes are the way they page 13 and 14.
Kindly,
You have been very good. You kept the car inside, but you forgot to cut the bushes.
kindly see, my lord, very substantial. My own brother, my lord. My own brother, blood brother.
So what you've done also the same thing to it.
My father said you construct the house here. I constructed it. Not that I deliberately.
Now you divide it into two.
Not, my lord, last time your lordship.
You can't force anybody.
Your lordship suggested that some mediation by some.
It's not agreement to it. He's been trying it.
The building will be sliced into two.
Let it be.
Substantial building, my lord.
Let it be.
My own brother, elder brother.
Be happy if it's sliced into two. At least both of you can share the same building. Express. You're not inclined to interfere with the impute plan.
Deeply applied.
In this case, the High Court had quashed
Appointments of assistant professors.
an order of appointment, an advertisement, and also yes, Lord. So, my lord, the final order of the High Court, of which we are asking for contempt, and where the single judge had framed charges also against these people, but the division bench has reversed the order of the single judge by saying, has quashed the framing of charges by saying that the posts for which the petitioners had applied for are not the posts on which these people have been appointed, and therefore that there is no contempt. This is what they say. Now just see the order.
What happened to the main litigation?
Main litigation was concluded because thereafter they filed an SLP against that order. That SLP was withdrawn. So therefore that has been concluded.
In your favor?
In our favor. The order, they said that we are withdrawing it in order to file a review in the High Court after many years. That review is still pending, but there is no order. There is no stay order or anything. Therefore,
which page is the order or the writ petition?
Yes, Lord. The order is reproduced in the affidavit, in an affidavit of the university at page 314.
Only for the subsequent development, Lordships will see para 25, page 8. There are two petitioners in this SLP. Both have moved on. One is now serving as a professor in Jamia Millia here, and the other has resigned long ago. And this is a 2013 advertisement. Many advertisements have been issued subsequently. Others have been appointed. These two are not interested in this litigation any longer.
That's why they are pursuing it.
Para 25 and page 8.
He's here.
That's
what's surprising.
They've engaged Mr. Bhushan to argue the matter.
One is a professor now. This is a post of assistant professor. He's now serving as a professor in Jamia Millia. Long ago. That's why the High Court notes this in page 8, para 25.
So let him take note of that. Yes, Mr. Bhushan.
Yes, Lord. So the judgment of the High Court.
Which page?
Is P6. The relevant part is, Lord, page 279, or rather 304 of the PDF. 279 of the paper book. So they say, in fact, 282 your lordship may come to. We have no hesitation to hold that it is only after the recommendations were received from the academic council that the police and planning board could have prescribed
qualifications in addition to those laid down by the medical council under so and so. In the absence of such recommendation of the academic council as contemplated, the advertisement as published on the recommendation of the board cannot be legally sustained, as qualifications mentioned therein had not been provided for in accordance with the statutes applicable. It is the settled principle of law that if a law requires something to be done in a particular manner, it has to be done in that manner or not at all. Privy Council so and so, so and so. And thereafter, my lord, they say, next paragraph, having arrived at the said conclusion, we find that petitioners 1 to 4 stand excluded from the zone of consideration from the posts in question as per the advertisement under challenge in the present writ petition only because of prescription of additional qualifications by the board. Since qualifications as advertised had not been fixed in accordance with the statute applicable, exclusion of the claim of the petitioners for the posts is therefore rendered bad in law. Similarly, we find that the petition number 5 could not apply because of additional qualification introduced in the advertisement. She is also entitled to relief. Then, my lord, page 286, final. So what it says is that 285. Just Mr. Bhushan, 1 minute. Yes. What it says is the advertisement as published was not in terms with the prescribed rules. Yes. Qualifications prescribed with the prescribed rules. Correct. 2, there were certain additional qualifications prescribed in the advertisement. Therefore, so then they say, for all the reasons recorded above, the writ petition, page 285 bottom, the writ petition is allowed the advertisement insofar as it pertains to the post of associate professor and professors in the Department of Orthopedics and Anatomy are hereby quoted. I may add, my lord, corrigendum was issued. It included ophthalmology also. So all 3 departments, Department of Orthopedics, Anatomy and Ophthalmology. But you had applied for which post? You had applied for which post? Sandeep Kumar, Orthopedics. So how can and ophthalmology. There are 2 petitions.
Yes. Can't quash it for the other one because nobody's applied for it. So leave that apart.
So
that we'll have to leave it apart.
But in any case,
no, but nobody applied. Nobody asked.
They applied.
No, please. You did not apply. We did you file that petition.
The people who are here.
But 1 minute, please. That's not relevant. What has been quashed by the operative portion of the judgment is confined to orthopedics and autonomy.
Anatomy and ophthalmology.
What is that?
That was
added.
Thereafter,
and after ophthalmology was added?
Yes, my lord. If your lordship just sees the page 314.
314.
Yes. That's an affidavit by the registrar.
So the judgment it was added or what happened?
Yes, by the judgment it was added.
Assistant professors.
Thereafter by corrigendum it was added.
Okay, fine. Okay, now what happened thereafter?
So if your lordship just sees page 314,
we've understood that. Then what happened after that?
So then they said in the same affidavit at page 314 bottom, they said that after careful consideration and compliance of the aforesaid judgment and order dated 17 February 2014 of the High Court, the appointment of R.P. Maurya as Assistant Professor of Ophthalmology in the Department of Ophthalmology has been cancelled forthwith by the Vice Chancellor by his order so-and-so, which has been communicated to Dr. Maurya in so-and-so. Thereafter, my lord, a photocopy of the order cancelling the appointment of Maurya as so-and-so is annexed to so-and-so. And thereafter, they also cancelled, दूसरे का भी cancel कर दिया ना? अच्छा. All right. So they cancelled one of these appointments on the basis of the High Court judgment. But they did not issue any fresh advertisement as directed by the judgment. So therefore, we had to move for contempt. In the contempt, just see first, my lord, what the single judge says. The single judge, while framing charges, page 325, says, in rebuttal, learned counsel for the applicant submits that
falsity and evasive tactics have been adopted by officials of the university in not only flouting the writ court order, but also circumventing the decision of the court. The Vice Chancellor in his order clearly records that in compliance with the interim order passed by the writ court, the envelope of the Associate Professor in Trauma Orthopedics was not placed before the Academic Council, whereas in the appointment letter dated 31st March issued to the opposite party number 4 clearly records that the Executive Council in its meeting dated 5th February 2014, that is after passing of the interim order on 3rd February 2014, was pleased to appoint opposite party number 4 as Associate Professor Trauma Orthopedics in the Department of Orthopedics. In other words, it is urged that the appointment letter clearly reflects that the writ court order was flouted and the order was placed before the Executive Council on 5th February 2014 despite the undertaking given before this court, because there was earlier an interim order restraining them from making appointments on the basis of that advertisement. Further, it is not disputed that opposite party number 4 came to be appointed in violation of the order and undertaking furnished by the authorities before this court. The Department of Orthopedics and Department of Orthopedic and Trauma Center are two different departments, would have no bearing for the reason that Associate Professor in Trauma Orthopedics was advertised under the heading Department of Orthopedics for 2 posts, one reserved for SC and the other under unreserved category. The plea of the Senior Counsel of the University that since Dr. Saurabh Singh applied in the post of SC category, therefore his selection appointment would have no bearing with regard to the post under unreserved category. The argument according to the Learned Counsel for the applicant lacks merit, and if the plea of the Learned Counsel for the University is accepted, it tantamounts to communal reservation, which is against the scheme of the Constitution. The advertisement for the posts under the Department of Orthopedics, that is Professor, Associate Professor, Assistant Professor, including Associate Professor in Trauma Orthopedics, came to be quashed and set aside. Therefore, the University could not have made any appointment against the post either in the SC or in the unreserved category. In the circumstances, it was not open for the University to have appointed opposite parties 4 and 5 against the advertisement that came to be quashed. It is admitted that till date, no fresh advertisement has been issued by the University inviting applications for the post under the Department of Orthopedics, Ophthalmology, Anatomy, and therefore there was no occasion of making the appointments. The operative part of the order on plain reading is unambiguous and there is no scope for 2 interpretations or comprehension. This writ court quashed the advertisement insofar as it related to the Department of Orthopedics, Ophthalmology, Anatomy. Further, approach of the University also does not appear to be bona fide for the reason that the University has cancelled the appointment of opposite party number 5, whereas they justified the appointment of opposite party number 4.
Opposite number 5 was appointed at writ post.
Opposite party was in ophthalmology, I think, 5.
Oh, yeah.
5 was in ophthalmology, which they said that they had cancelled. 4 is in orthopedics, Saurabh Singh, whose appointment they kept on a specific query. Learned Counsel appearing for the University, now this is important, does not dispute that the post against which opposite party number 4, 5 were appointed was the post of Assistant Associate Professor set aside by the writ court. Further, the first applicant was the third petitioner in the writ petition and had applied against the post of Associate Professor of Trauma Orthopedics, against which opposite party number 4 has been appointed. So, and then they have now, Lord, in fact, they have used a forged form of mine, which is totally different from the form that in which they claim that I had said that I am not interested in being appointed to the unreserved category. Whereas I had said no such thing. Though I am SC, but I said, I didn't say any such thing that I am not interested. The same post, one is scheduled caste, one is unreserved. Why would I say that I am not interested in the unreserved category? Just see, my lord, that forgery, the forgery, they have annexed this document which is in the additional application for additional documents. page 7 of that additional document, that is 452 of the PDF. 452 of the PDF. This is so serious, this forgery.
Number 180520. Give me the other file.
There's
only one application for additional documents.
Yes, that's right. In that page 7, internal page 7.
715, an application form.
Yes, that's the one.
Yes, no, I don't have the second.
So,
application.
Okay.
I used.
Just see page 7.
Page
7. In order to say that, look, these posts, that the petitioners had not applied for this post, unreserved post, they annexed this form, in which, just see, item 13, item 13,
yes,
category SC, correct?
Yes.
On top lot position applied, associate professor, Department of Orthopedics, correct?
Correct.
13 category SC, 14 category, consider in general category no. This is what they have written. Now see my actual form. My actual form, my lord, is at page 8, next page. There was no column in the form. In my form, which I had filled, it only said category SC. There was no column saying consider in general category. This they have just added by way of forgery. So serious. Why would there be a column saying consider in general category, and why would anybody say don't consider me in general category? It was not there. And this column has been added by the university.
You have signed this form as true copy?
Yes. No, true copy is what they, the university
What is
used.
this?
Well, may I just
What
explain?
is happening? What is the problem?
May I just explain?
How did you appoint them after striking down?
These are all online forms.
No, that's fine. But how did you appoint them after the advertisement was struck down?
No, my lords. In fact, that was not struck down. My learned friend has not taken your lordship's chronologically to the facts. If he has finished, I can do that because I don't want to.
That's one thing. Why?
This was not struck down, my lords. Orthopedics trauma was not struck down at all. In fact, the person who applied for that post.
Advertisement first.
Yes.
Split up.
Correct. This was not. The advertisement is there, my lords. May I just take your lordship straight with that? No, you may just indicate what really happened. A person, this was reserved for the scheduled caste. The person who got selected for the trauma post applied to the High Court in a separate writ petition, got an order which we had to implement. So we implemented that order. Then he wakes up and he says, no, the trauma post was also struck down, which was never struck down, my lords. The trauma post was never struck down. It was not asked to be re-advertised. So there's a very detailed order passed distinguishing posts in the orthopedics department from the trauma department. So there was no question of violating any order at all, with the greatest respect. Well, that's what really has happened is this. This is a 2013 advertisement. 2014, all of this happens. We have since then moved on, my lords. As far as these 3 posts which were struck down, we didn't appoint anyone.
Posts to which you are appointed, or
there's an additional factor. Those vice chancellor, that registrar and vice chancellor who were at the relevant point in time, one has died. The other has retired and he's no longer involved in any of this. We have come in as present office bearers.
I'm saying
And we
they
have
to
been
comply.
broken. In 2020, charges
But
are
what
framed.
happened after the order was passed? What happened thereafter? How did these people continue?
No, nobody continued, my lords. With the greatest respect, I don't know why he's not telling your lordships this.
Please let us ask him to answer.
My lords, nobody was selected against the 3 posts which were quashed. That advertisement stood withdrawn, my lords.
That advertisement stood withdrawn. Then what
There was
happened?
one post in the trauma orthopedics for which a person who got selected went to the High Court and said this was not covered by your order. So asked them to appoint me. The High Court asked us to appoint him. The same judge who struck down the advertisement for these other posts, asked us to appoint Dr. Saurabh, and he was appointed.
And now today, the only
Saurabh is
question
working. These 2 people.
No. The only question is of whether Dr. Saurabh was rightly appointed or not.
And Saurabh has not made a party here. Saurabh has not made a party here. These two gentlemen. Well, these 2 gentlemen have moved on. Now, 2013.
Which page is that?
Oh, advertisement. Annexure P1. Annexure P1, my lords.
Page number?
11 is 174.
These departments are at which page?
Well, as these departments, I'll just tell my lord straight away. Page 148, if your lordship sees. Page 148. 148, 149, 150. Your lordships will find trauma is separately indicated. 149.
How many posts were advertised at that time?
Well, it's 1 post each, my lords. Just 1.
No. Total number, because I can make out.
No, that's a code. That's a code. 1496 is the code.
So this is a part of the advertisement.
Yes.
But there are number of posts advertised.
No.
There are number of posts advertised, Mr. Mulidar.
The advertisement was for over 400 posts.
Correct.
For this particular.
That's in your favor. Why are you shining?
No. For this particular post, there was only 1 vacancy. That's why.
And this was not what was struck down. This post was not what was struck down.
The trauma post was not struck down. Your lordships see the distinction between the ophthalmology post, the orthopedics post, and that trauma post.
No, it was clearly struck down. I can show it to your lordship. Just see, they said.
Which is the exact one.
If your lordship just says.
These are 2 different.
Yeah.
Next time we'll just we'll have Mr. Mulidar. We are not closing your right to answer.
If your lordship sees the
On the other hand, without you concluding the argument, we put them to task. We put them to shoot on the question of the orthopedic trauma course was a separate.
Yes.
According to you, therefore, it was because it was separate. You did not treat it as concern.
Well, they had not applied for it, so they never asked for its quashing. As simple as that, my lords. What they had applied for was the orthopedics post.
Orthopedic trauma centers.
SC category for both orthopedics.
Where is the corrigendum order passed by the High Court?
Yes. I'll straight away refer the corrigendum order of the High Court. Corrigendum order of the High Court.
Corrigendum order is recorded in the.
No. It's only in the list of dates. Lordships will find that.
The order is not here.
It's not. But we are not on issue on that, my lords. There was a corrigendum order. But the corrigendum order would include ophthalmology. It did not include trauma center.
Included
Ophthalmology.
Orthopedics.
Yes, my lords.
So we'll have to see that order as to whether it drew a distinction between orthopedics trauma center and orthopedics simpliciter.
Very well, Mars. We can get that.
You have a copy of that order, Mr. Bhushan?
Where is it? Corrigendum.
Yes, bro. So if your lordship just sees the advertisement.
Page F, if your lordship
page
sees.
150.
150.
Yes.
Well,
This
it's
is the advertisement.
That order is at page F, Malaj.
Page F.
F.
They stated that this is the judgment came to be corrected. This is all that they have stated in that.
No, was added. Well, it's page F, if your lordship sees, the judgment came to be corrected on 11/3/2021 and 1/4/2021 respectively. The post of assistant professor and department of ophthalmology was added respectively. So assistant professor in orthopedics and assistant professor of ophthalmology was added.
Orthopedics was already there.
Already there, Malak. So only ophthalmology. If lordship sees the operative portion for the reasons recorded above, just the earlier page, the writ petition is allowed. The advertisement insofar as it pertains to the post of associate professors and professors in orthopedics and anatomy are hereby quashed. So only orthopedics and anatomy was quashed. By the corrigendum, they included ophthalmology.
Orthopedics was already quashed.
Yes. And what was the person who was appointed was to the orthopedics trauma center.
That was a separate category. That was
SC category. The SC category in orthopedics trauma center.
But they also the qualifications prescribed for all assistant professors posts were there was a change only for these three posts.
They'd asked for only these three, Mallards.
No. Actually, in true facts, was the several assistant professors posts were advertised.
Please, Mallards.
The changes which are made contrary to the rules would have been across the board.
Please, Mallards.
Including the posts
of orthopedic, maybe. We don't know.
Yes.
We don't know. Well, we don't
yes
know.
or no, Mr. Bhushan?
Yes, of course.
So, because
across
you cannot have a post of assistant professor, the qualification prescribed will be uniform in all the posts. But in your favor, we can say that what was quashed by the High Court was specific three posts. And orthopedics trauma center was not specifically quashed.
Please, Manoj.
And therefore, on that basis, you went ahead. And
I also went ahead because of the subsequent order in Saurabh Singh's writ petition by the same judge.
You said that please appoint him.
He said, please appoint me.
Where is that order?
That order is here, Manoj. Annexure P8, if your lordship sees that.
Which page?
Page 289.
It's a subsequent order.
Yes. No. 289 is something else.
SANJAY, how can it be? This is the order.
So I'll just tell your lordship.
That's appointment order. 289 is the appointment order.
287, Manoj, Annexure P7. P7, 287.
Yes.
No, but this one is on behalf of the respondent, Banaras Hind University. It is stated that the result of.
Well, it's a statement is made on behalf of the university that the result of the selections held shall be declared, keeping in mind the judgment of this court in Abhishek Chandra, which is that writ petition. Within 2 weeks from the date, a certified copy of this is filed. Because in Saurabh Singh's case, he said, I have been selected to the post of trauma center, and I should.
So it was left to the authorities themselves to decide whether they cover the judgment or not.
The next page 289, is a very detailed order passed by the then Vice Chancellor, who is now no more, Dr. Lalji Singh.
Okay.
Page 289.
Yes.
Well, this is a very, very detailed order.
The judge should have decided the trial.
I'll clear this issue up in 1 minute only. That the post that was advertised for trauma orthopedics is precisely the post which was quashed and which the university accepted that this post was quashed by the High Court judgment. If your lordship now sees.
Just 1 minute, let him read this order. We'll come
very clear.
289.
Own admission.
Yes, 289. The first paragraph, it's very, very clear. In view of the direction of the High Court dated 26th March, given writ petition so-and-so, the representation dated 27th March by Dr. Saurabh Singh is decided as below. Whereas it has been considered that the order passed by the High Court on 17th February in writ petition so-and-so was part of the record in writ petition 17668 of 2014, whereas it has been considered the writ petition so and so, the applicant was not 6598 of 2013. At para 16, the petition number 3 explicitly stated that he is an applicant for the post of orthopedics advertised under SC category. Thus, the post on which the present applicant claims, that is Saurabh Singh claims, is not the post covered under the order dated 17/2/2014 in the aforesaid writ petition. Whereas it has been considered that the post code 2657 in the rolling advertisement in the inception belongs to trauma center. Since the Department of Trauma Center was not yet formed, the respective posts of trauma centers were advertised under corresponding departments for the sake of convenience, so that the prospective candidates can easily find these positions in an online advertisement. Whereas it has been considered that the judgment and order dated 17/2/2014 pertains to the post of Associate Professor in the Department of Orthopedics, and its advertisement has been quashed thereby, the petitioner has made a claim in the post of Trauma Center, not in the Department of Orthopedics, as the post belongs to the Trauma Center since its inception. Whereas it has been considered that the petitioner applied for the post of Trauma Center and was issued call letter for interview for the post of Associate Professor in Trauma Orthopedics, Trauma Center. Whereas it has been considered that the spirit of the order in so-and-so dated 26/3/2014 directs the Vice Chancellor to dispose of the representation of the petitioner in the light of the order dated 17/2/2014, which refers to the advertisement of the post of Associate Professor in the Department of Orthopedics. The faculty positions sanctioned under 12th plan by UGC have been allocated separately for the Trauma Center as a new department, reinforcing that the Trauma Center is a separate unit from the Department of Orthopedics. And whereas it has been considered that the Executive Council meeting dated so-and-so, the envelope for the post of Associate Professor in Trauma Orthopedics was not placed before the Executive Council for the reason that the interim order dated 3/2/2014 was for posts which are subject matter of consideration of the writ petition. Since petition number 3 was also an applicant for the post of Trauma Orthopedics under SC category, though he has not claimed his candidature in the writ petition for the UR category, the university, for the sake of being cautious and giving due regard to the spirit of the interim order, did not place it before the Executive Council. Now, therefore, after considering the entire material with a view to comply with the order of the decision dated 26/3, it would be appropriate that the result for the Associate Professor, Trauma Orthopedics in Trauma Center be declared. May I just pause here?
Yes, Mr.
Two orders are faced with, the Vice Chancellor is faced with two orders. He has to comply with one of them.
Mr. Bhushan, now what's the right?
The post of Associate Professor in Orthopedics, to which this Saurabh Singh has been appointed, is post code number 2657. Now just see page 267. 267. P4. First, my Lord, P3, your Lordship may see. This is the order of the High Court, interim order of the High Court. This is the interim order dated,
3rd February.
3rd February, right. Now just see page 265. It has been stated by the Learned Counsel appearing on behalf of BHU that till 7th February, the recommendations made for the posts that are the subject matter of consideration in the present writ petition shall not be put up before the Executive Council. List put up this case on 7th February. Now see the next page. This is the Executive Council order of 5th February. And then at page 267 it says, resolved further that the Vice Chancellor be authorized to open the envelope and approve the recommendation of Selection Committee in the case of posts of Associate Professor of Ophthalmology, post code 2655, and Associate Professor of Orthopedics, post code 2657, as and when permitted by the court. Now see what is 2657, which was clearly the subject matter of this writ petition. That is annexure that tum dikha rahi thi na, the advertisement.
Page 149.
Page 149.
148, 149.
150, my lord. The relevant page is probably 150.
The code is mentioned in the second column.
150. See at the top.
6%. 1 minute. And you go one page before?
Yes.
There it is 2656.
professor, that is the general. That is, this one is, this is associate professor. First it says.
No, you are right to that extent, you are right.
Well, in fact, we did not place it before the Executive Council because of the subsequent order of the High Court, we were forced to consider.
High Court doesn't say that.
What choice did we have, my lord?
Doesn't your application form refer to the code of the post that you applied for?
Yes, yes.
Does it? Where is it?
You must have either, for applying for two different posts, you'll have to fill up two different forms. You would have specified whether it's for trauma center or for orthopedics normal.
So I applied for associate professor of orthopedics.
Not for trauma center.
No.
You did not apply for trauma center.
You may not have applied for that particular.
Leave it then.
But then.
Leave it now.
No.
The top itself, it says
It's a very gross case because. Because, my lord, they said. It's not just orthopedics, my lord. I am ophthalmology. I am also ophthalmology. And even in ophthalmology, my lord, they have not re-advertised the post.
Doesn't make a difference.
I am also waiting for that, my lord.
You can't be waiting for after 10 years. You're already a professor. Don't come down.
I am, my lord. Otherwise, my lord, they will be permitted to.
They are not inclined to interfere with the judgment and especially petition.
On the basis of.
Okay, other matters next week.
I'm obliged.
There's one passed over matter.
Item 40 in today's board.
And the
main is listed tomorrow, my lord.
No.
Item 40 in today's board.
Which is that?
It's a mining matter, my lord.
How will it be listed tomorrow? It will
my lord, it's the same impugned order.
Pardon?
My lord, it's the same impugned order which is there in item 40, which is listed as item 27 tomorrow. This matter was directed to be tagged with that matter, my lord. So all I'm saying is let that be tagged, my lord, and let it be listed.
No, let 37 come up on its own. We're not going to.
27 tomorrow, man.
27, let it come up on its own. We'll see.
It's the same, that's why.
Ab rakh lena iski file, bhejna mat, that's all.
44.3. 44.3, my lord, today's fresh matter.
Remain on board.
Will remain on board.
Same remain next Thursday.